Just another quick announcement. We'll go ahead and get started at 8:35. That's in 1 minute. We'll go ahead and get started at 8:35.
That was just gonna be my ask. If we get your hand and whatever, I'm prepared to waive it off. If you're not coming back to me. Okay, Woody? Yep. You sure that this 60 day thing, looks to me like they changed it, at least in some places. There on my tab. Oh, yeah, it is. God, you said something. That would've been bad. Yeah, so you're looking right here, right?
All right, let's go on the record. Good morning. My name is Charles Hatcher. I'm the regulatory law judge presiding over this hearing. Today is January 25th, 2022. The commission has set this day for an evidentiary hearing in file number EO-2022-0061. For the record, we are having a hybrid hearing, and that means that some participants are physically in person here in courtroom 310. Others will be participating via WebEx, and that is a video conferencing internet application. The WebEx participants will be viewing a monitor showing the live stream. The WebEx participants will have all the same abilities and responsibilities as those in person. The WebEx video will not be part of the record and will not be viewable by those viewing the PSC live stream. The broadcast audio, however, will be taken down by the court reporter as part of the record. I have a couple of WebEx announcements specifically. I do ask that everyone please mute themselves. We will proceed slowly at every step to allow for unmuting. The WebEx chat function is not private. Phone users, if you have called in, please use *6 to unmute. And a warning for the attorneys, if you have your client in the same room as your WebEx, the computer microphones these days are good enough that whispered conversations have been overheard on the WebEx. Let's go ahead and move on to entries of appearance. First for Evergy, Mr. Fisher, please.
Yes, Judge. Let the record reflect the appearance of James M. Fisher and Roger Steiner on behalf of the company in this case. Our contact information is included in the application and other pleadings in the case. Thank you.
Thank you, Mr. Fisher. For staff, Mr. Keevil.
Yes, Judge, appearing on behalf of staff, Jeffrey A. Keevil, P.O. Box 360, Jefferson City, Missouri, 65102.
Thank you. And Mr. Kleiser.
John Kleiser, appearing on behalf of the Missouri Office of Public Counsel. My contact information has been provided with the court reporter.
And Velvet Tech Services, Ms. Bell.
Yes, Stephanie Bell and Mark Ellinger with Ellinger and Associates on behalf of Velvet Tech Services, and our information was included.
I can't hear him.
Ms. Bell, could you maybe move that microphone a little closer to your mouth? And we'll try over here to turn the volume up.
Sure.
Go ahead again.
Stephanie Bell
Perfect, thank you.
and Mark Ellinger with Ellinger and Associates for Velvet Tech Services, and our information is included in our application to intervene.
Thank you, and Mr. Mills.
Thank you, Judge Hatcher. Lewis Mills of the law firm of Brian Cave Leighton Paisner on behalf of Google LLC. My address is 201 Bolivar Street, Jefferson City, Missouri, 65101.
And Mr. Woodsmall.
Thank you, Your Honor. David Woodsmall on behalf of the Midwest Energy Consumers Group. Your Honor, I didn't print out my opening statement. Can I leave while you take up everything else, and I'll be right back? Don't slow down the opening statements for me, is what I'm saying.
I won't, but I'm going to have a pressing announcement you want to hear in just a minute. Let's move to preliminary matters. I have two. The first is perfunctory. This is about the exhibits. Just to ease the confusion during COVID, I, the regulatory law judge, will take responsibility again to make sure and get marked and submitted to EFIS the pre-filed testimony that is in EFIS and any exhibits that anyone produces today and they email it to me. They can, the other normal procedure is to email it to exhibits@psc.mo.gov. I will revisit those instructions later. My second announcement concerns the schedule for today. Late last night at approximately, or exactly 4:49, and then later at approximately 8 p.m., the parties, if I can describe them as two sides, have filed what could be called competing tariff wordings. In comparing these last night, I found that there were many similarities and there were a few differences. Not everyone has had as much time as I have to work after hours and overnight to read through these tariffs. So what we're going to do is we're going to go through opening statements, and then we're going to break until 1 o'clock. The commission has some very pointed questions about the two provisions, and the commission wants to go through each provision, asking each witness in turn why this is there or why they disagree. So in order to accomplish this in the most efficient way possible, and in order to keep the hearing on schedule, in order to continue trying to pursue expedited treatment as requested, the commission seeks to have all the witnesses prepared for those questions. So just putting that out there for everyone to know, that's the direction for the questions. Yes, Mr. Keeble.
When you say the provisions, are you referring to the tariffs which were filed with the competing stipulations? Those are the two, okay.
Yes, sir.
Because there were several other versions previously filed, that's why I wanted to clarify.
Yes, in preparation for the hearing, I also printed those out. And then last night, lo and behold, someone had compiled several of them into these two. So I think that's the intent of the parties, is to use these two as a starting point. And therefore, in response, the commission wants to have opening statements, hear the lay of the land, and then give everyone, particularly the witnesses, a few hours break to go over and be prepared to answer the detailed questions of why you agree or disagree line by line. Okay, where are we at?
Judge, this is Jim Fisher. In order to make that more efficient, would you like for the council to have a little bit of direct with the witness to go through those provisions, or should we just wait for the commission and the judge to ask his questions?
I would prefer, if I may, that the commission ask its questions and that we can clean up on redirect if necessary. That would be my preference.
On WebEx, did you hear that?
Yes.
Mr. Mills? Okay. Well, was that acceptable?
That's acceptable to me.
Well, so I can get out of making a decision. I wanted to see if Mr. Mills will just agree.
Judge, I have no objection to that procedure.
Excellent. We will do that. And we will proceed to opening statements then. Let me check my handy list. Evergy will be doing the first opening, and for everyone's information, this will go Evergy, Velvet, Google, staff, OPC, and then NECG. Evergy, the floor is yours.
Thank you, Judge. I do not have a PowerPoint this time. I'm just going to be giving an opening statement. In order to serve bandwidth, would it be helpful for me to turn the video off, or would you prefer to see my face?
No, you're fine. Go ahead, Mr. Fisher.
Okay, thank you, Judge. My name again is Jim Fisher, and Roger Steiner and I will be representing Evergy Missouri West in this proceeding today. Evergy has been approached by multiple potential customers seeking to locate large, high load factor facilities in the Kansas City area. Most of these high load factor loads are data centers. These customer loads have the potential to be much larger and more consistent than loads currently served by Evergy Missouri West. Now, there's a common need expressed by these customers for dynamic rate designs that allow them to competitively meet their corporate renewable goals. This case involves Evergy's request for the approval of a proposed special high load factor market rate tariff. This tariff is designed to meet the needs of these large high load factor customers by providing an energy rate based upon the day-ahead hourly price of energy observed from the Southwest Power Pool integrated marketplace. And for the court reporter, I'll probably refer to Southwest Power Pool as SPP. All other elements of the proposed rate are determined based on the incremental cost to serve the customers. Attracting large, high load factor customers to Missouri would be a significant economic win for the state. The ability of Missouri to win such projects over the competition from multiple other aggressive states exemplifies the public-private partnership approach to economic development taken in Missouri. The price of electricity comprises a substantial component of a data center's operating and expense cost. Therefore, a competitive electricity rate is very important to large data centers and represents a primary factor to their decision to locate in Missouri. Velvet Tech is an intervener in this case and is what we refer to as a design case customer that could be served under the proposed tariff. To better describe their need, involvement, and support, Velvet has provided a letter of support which is attached to the direct testimony of Darren Ives. Morris Brubaker, an outside expert with many years of experience before this commission and many other commissions, has also filed surrebuttal testimony on behalf of Velvet, which addresses the needs of this design case customer. The design case customer has purchased land and received approval from the Kansas City City Council for the construction of the data center. The expected construction cost of the data center is approximately $800 million and will employ 50 full-time employees. Current plans call for the data center to be in service by the end of 2023. Installation and commissioning of data center equipment will follow, and the load will increase as the data center builds out. The data center will be part of the Golden Plains Technology Park, an innovative 882-acre data center campus development in Kansas City, Missouri. During the ramp-up period, Velvet will be eligible for the Economic Development Rider, which I sometimes refer to as the EDR, which is authorized by Section 393-1640, and Evergy's EDR tariffs, which are called the Missouri West Limited Large Customer Economic Development Discount Rider, Schedule PED. This is a very important provision to Velvet and other large data center customers that would be building in Missouri. After the ramp-up period, which may last approximately 2 years, then Velvet would be eligible for the special high load factor market rate that is the subject of this proceeding. Let me digress for just a moment, Judge. As you mentioned, last night, staff, public counsel, and MECG filed a non-unanimous stipulation and agreement, which we will address in the proceeding as you suggested. But at this point in my opening, I think I need to bring to the commission's attention one provision in the tariff attached to that non-unanimous stipulation filed by staff, public counsel, and MECG, which we believe may potentially kill the possibility of a large high load factor data center like Velvet from coming to Missouri and accepting service under the special high load factor market rate tariff. Customers like Velvet need a way to transition to the MKT rate. The Economic Development Rider is designed for large loads and design case projects that have ramp-up periods over several years. The statutes, particularly Section 393-140, provides a means to offer limited competitive pricing for such customers. If the company is unable to use such pricing mechanisms as a transition, then the project economics will be threatened and other locations will be given a competitive advantage. The position filed by these parties includes a provision that the special high load factor market rate tariff would only be available if the customer, and I'll quote from their tariff, has not accepted a discount under Section 393-1640 in the past 5 years. This statutory section refers to the Economic Development Rider. This tariff provision, if adopted by the commission, would potentially be a deal killer and would certainly be a significant negative signal to new prospective customers in regard to Missouri economic development and electric rate competitiveness. And for that reason, I would urge the commission to reject that proposed addition to the tariff. I'd also like to point out that there is no pre-filed testimony filed by staff, public counsel, or MECG which addresses this provision. It is not included in the joint list of issues that was filed by the parties, and it is not mentioned in any of the position statements filed by staff, public counsel, or MECG. Darren Ives will be available to address this provision, which will effectively keep data centers from coming to Missouri, and at least in taking service under the proposed special high load factor market rate. But back to more of my prepared remarks. In order to support this construction schedule, Evergy, Velvet, and Velvet request a decision by the commission so that the special high load factor market rate can be effective by March 31st, 2022, and support customer decisions to continue investment at the site. Under the proposed tariff, customers must have a monthly demand of 100 megawatts or be reasonably projected to be at least 150 megawatts within 5 years of the new customer first receiving service from the company, as well as have an average annual load factor throughout the year of 85% or greater. The details of the proposed tariff are contained in the direct testimony of Darren Ives and his attached schedule DRI-1, with proposed modifications to the tariff included in the surrebuttal testimony of Brad Lutz. And as I'll explain in a moment, many of the modifications were intended to address the concerns raised by staff and public counsel witnesses in this case. In addition, Evergy and Velvet filed a non-unanimous stipulation last night, which has a tariff that includes modifications to the original tariff, which are acceptable to Evergy and Velvet. This non-unanimous stipulation and agreement represents the joint recommendation of Evergy and Velvet in this proceeding under the Commission's rules related to non-unanimous stipulations and agreements. Evergy West chose to design a simple three-part rate for providing service to these large, high load factor customers. The key element is the energy pricing. The energy price is set by the Southwest Power Pool day-ahead hourly price at the Evergy West node. The customer service charge and the capacity charge are based on the incremental cost to serve and negotiated amounts to address design risks. This tariff is similar to a tariff that Velvet brought to the attention of Evergy that has worked well for the Omaha Public Power District. That rate structure was approved in 2017 to provide service to large transmission level customers in the Omaha area, providing their customers access to SPP energy prices and bringing economic development benefits to the area. It also supported customers in meeting their renewable energy goals by pricing retail energy at SPP market prices to align with pricing of customer renewable projects on the SPP grid. Similarly, high load factor customers like Velvet would be served under the special high load factor market rate tariff and would not be served under Evergy's base rate, fuel adjustment clause, or renewable energy standard rate adjustment mechanism, which sometimes I refer to as RESRAM. The SPP energy pricing reflects the cost of fuel and other fuel-related incremental costs, and it's therefore unnecessary to have Evergy's fuel adjustment clause apply to these customers. The RESRAM would not be applicable to Velvet since Velvet will be sourcing sufficient renewable resources to cover 100% of its expected load, exceeding the 15% renewable energy standard in Missouri. Under these circumstances, it's not appropriate to require Velvet to pay a second time under the RESRAM for covering Missouri's renewable energy standard requirement. In this case, Evergy is seeking only the approval of the special high load factor market rate tariff, or what is sometimes referred to as the Schedule MKT tariff. Evergy and Velvet have not finalized a market rate contract at this time, but an exemplar special high load factor market rate contract, which will be used in the future, is attached to Mr. Ives' testimony as Schedule DRI-2. This contract example is intended to inform the Commission of the general form of a future special high load factor market rate contract. If the tariff is approved by the Commission, the company plans to file a market rate contract under the terms of the tariff at a future date, currently expected to be in early 2025. At that time, Evergy will seek approval of the actual contract with the data center customer. As I mentioned, and the judge noted, last night, Evergy and Velvet entered into a non-unanimous stipulation and agreement that recommends the approval of the special high load factor market rates, Schedule MKT. Attached to that stipulation is a red line tariff, which represents the joint recommendation of Evergy and Velvet. Under the terms of paragraph 4 of the stipulation, the signatories are recommending the approval of the special high load factor market rate tariff, which is attached to the stipulation. Under the terms of paragraph 5, there will be extensive cost and revenue tracking. Now, these are significant ratepayer protections to ensure that other customers are not adversely affected by the high load factor customers that are a part of this tariff. These protections are also found in paragraph 4 in the contract documentation section of the tariff itself. The specifics of these protections are contained in paragraphs 5A through 5C of the stipulation. The commission staff and other parties will be kept informed through detailed and regular reporting commitments. The anticipated reporting format is similar to what was agreed to and approved by the commission in file number EO-2019-0244 involving the Nucor contract. Under paragraph 5A, Evergy Missouri West will identify and isolate the plant costs and revenues to provide service to the contract customer. Under paragraph 5B, Evergy Missouri West will also identify and isolate the supply costs attributable to the MKT contract customer. These are expected to consist of energy priced at the SPP day-ahead marketplace hourly prices for the Missouri West load node and will be accounted for at these rates. Paragraph 5B includes the categories of costs which will be used to track and settle customer loads. It also includes provisions for identifying and tracking costs of capacity. Under subsection 5C, all revenues received from the contract customer will be tracked, including any negotiated special contributions. Related provisions are contained in the modified tariff being recommended by Evergy and Velvet, requiring periodic reporting and provisions to identify the customer's costs and revenues for consideration in a general rate case. At numbered paragraph 4 of the modified tariff, the tariff includes what has been referred to as a hold harmless provision to protect the other Evergy customers. Non-participating customers will be held harmless if the commission determined that there is any deficiency in the revenues compared to the cost to serve the contract customer. In the event that the commission ordered a deficiency adjustment, a rate adjustment sufficient to pay for half the determined deficiency adjustment would be made to the contract rate customer, with the remainder of the deficiency adjustment being borne by Evergy. Under this protection, non-participating customers would not bear any of the deficiency found by the commission. While we think this type of deficiency adjustment is quite unlikely, this type of provision is important to public counsel and staff and has been included in the tariff being recommended by Evergy and Velvet. Paragraph 6 addresses two proposed variances from the Commission's Renewable Energy Standard rules, which are found in 20 CSR 4240-20.100. Under the first variance, the rule definition of the total retail electric sales, which is defined in the rule at subsection 1W, would not include the contract customer's load. The signatories agree that if the MKT customer demonstrates that it has retired or had retired on its behalf renewable energy credits greater than or equal to the then existing RES requirement applied to the MKT customer load, then the schedule MKT customer retail sales are not included in Evergy's calculation of its RES portfolio requirement in subsection 2 of the rule. This variance would ensure that Evergy's RES requirement would not be increased as a result of the contract, since the contract customer would have already covered the state's existing renewable energy goals. And under the second variance, the RES compliance costs needed to serve the Schedule MKT customer would not be characterized as part of the company's RES requirement under the section 20.101 S1. Now, these two variances, the effect of the variances are to recognize that Evergy's RES requirements and the RES-RAM itself should not be affected by the contract customer's participation, since the customer will have demonstrated that it had retired or had retired on its behalf RECs equal to or more than perhaps what would otherwise be considered its share of the RES standard compliance costs. Paragraph 7 is designed to ensure that the contract customer's participation on the system would not affect the rate limitations on other large power customers contained in the PISA statute, which is section 393.1655. This provision was approved by the commission in the Nucor case as well. Now, Evergy's witnesses, Mr. Darren Ives and Mr. Brad Lutz, will be happy to address any of the commission's questions that it has about the non-unanimous stipulation and the attached tariffs. They'll be available at 1 o'clock to discuss and compare the provisions of both the Evergy Velvet tariff and the tariffs attached to the non-unanimous stipulation of staff, public counsel, and MECG. Very briefly, I'd like to just turn to a couple of the concerns that were raised by the parties in the case. As I mentioned, Evergy has made modifications to its proposed tariff, which are attached to the Evergy Velvet non-unanimous stipulation. Many of these changes were in direct response to the suggestions made by staff and public counsel witnesses. And we'd like to thank the staff and public counsel for making these suggestions, which we believe have improved the provisions contained in the tariff itself. While we obviously were not able to settle the case due to some of the issues I'll discuss, I think many of their proposals have been constructive, and we appreciate their work on the tariff provisions. Now, turning briefly to some remaining issues. Staff and public counsel have suggested that the proposed tariff is discriminatory, based largely on the fact that the company's originally proposed tariff was limited to customers that fell under specified industry codes, which are referred to as NAICS codes 518210 and 541511. These relate to data centers. Now, in response to that concern, the company has agreed to delete that provision from the availability section of the tariff. Instead, the tariff would be available to all large customers with a specified load and annual average load factors of 85% or more that met the availability requirements. Staff has also suggested that it was unlawful to exempt customers from the FAC and the RES-RAM. Now, I've already addressed the policy reasons why it would not be appropriate to apply these riders to the customers like Velvet. But under Section 386-266, the Commission has the statutory authority to authorize, in its discretion, a fuel adjustment clause, but that statute does not require that it do so. It's within the Commission's authority, as it determines just and reasonable rates, to exempt customers such as Velvet from the FAC when the contract pricing structure does not make sense to have a separate fuel adjustment clause component. For example, the commission has approved the Nucor contract, which does not include a fuel adjustment clause. And I did note that the staff and public counsel tariff, which is attached to their non-unanimous agreement, also now recommends that the fuel adjustment clause should not apply to the Schedule MKT customer. Similarly, the rules on renewable energy standard authorize electric companies to establish a RESRAM, but the rules do not require it to do so. As I mentioned, in this case, Velvet will be sourcing renewable energy to cover 100% of its load. And it would not make sense from a public policy perspective to apply a separate renewable energy standard surcharge to this customer and require Velvet in effect to pay twice or more for renewable energy resources. As I've already discussed, in the Evergy Velvet non-unanimous stipulation and agreement, the parties have suggested the commission should grant a variance from the commission's res rules to exempt customers like Velvet from who are securing or sourcing their renewable energy requirements themselves from having to double pay for renewable energy facilities under the RESRAM surcharge. Staff also questioned a provision in the company's proposed tariff that would allow the company, in its discretion, to add more voltage levels to the tariff. This, or in their discretion, they could add those voltage levels. This particular provision has also been removed to address the staff's concern. Staff also suggested that if the company is required to build facilities solely to serve the customer and the customer's additional load requirements, then the tariff should state the costs are identified and recovered from the customer. These costs will be identified and recovered from the customer and will be specified in the market rate contract that will be filed at a later date for the commission's approval. Staff also suggested that the time for reviewing the provisions of the market rate contract should be lengthened beyond the 60 days that was originally proposed in the tariff. In response, the company has revised its proposed timetable to a 90-day review period. The staff also raised concerns to ensure that the Schedule MKT related costs are not included in the fuel adjustment clause charge recovered from other customers, and further ordered the commission to track those related costs separately from other costs specifically identified in the FAC monthly reports submitted to the commission. This concern has been fully addressed in the cost and revenue tracking section of the non-unanimous stipulation and agreement. So, in conclusion, Evergy believes that its proposed modifications of the tariff had addressed concerns raised by staff and public counsel. And Evergy will be sponsoring the testimony of 4 witnesses: Michelle Hadaway, the Director of Regional Engagement Division from the Missouri Department of Economic Development, who will be adopting the testimony of Mr. Mark Stombaugh. And she's not available until tomorrow, so we can take her out of turn if that would be appropriate, or if people want to waive on cross, we might be able to shorten it. The second witness is Miss Jill L. McCarthy, the Senior Vice President of Corporate Attraction, leading a high-achieving recruitment team in the Kansas City Area Development Council. She will be available, excuse me, I think it's Jill that's not available until tomorrow. And then Brad Lutz, Director of Regulatory Affairs for Evergy, and Darren Ives, the Vice President of Regulatory Affairs, will be available to answer all the commission's questions regarding the differences in the tariff proposals and our stipulations. So in conclusion, the company would respectfully request the commission approve the special high load market rate tariff as modified in the Evergy Velvet non-unanimous stipulation and agreement, and the form contract with additional customer protections contained in the non-unanimous stipulation and agreement signed by Evergy and Velvet. I appreciate your patience on this longer opening statement, and I'd be happy to answer any questions.
Thank you, Mr. Fisher. Are there any questions for Mr. Fisher?
Judge, this is
Thank you.
Chairman
Yes,
Sylvie. No,
go ahead, Mr. Chairman.
I was just going to say no questions, but letting you know I'm here.
Thank you. And on that note, I did want to state for our court reporter that on WebEx, we do have all 5 commissioners, Chairman Sylvie, Commissioner Coleman, Commissioner Holzman, Commissioner Kolkmeyer, Commissioner Root. We'll move on to Velvet's opening. Ms. Bell?
Yes, Your Honor. Confirming that you received a copy of my slides, which were emailed, and that they are available on the screen.
Yes, heading there now.
Okay. Do I need to screen share them on the WebEx?
Why don't we go ahead and do that? I'll pull up the WebEx on that monitor, and so then you can just screen share from there.
Judge, I can't hear her. Is there any way you turn her up?
Is this better?
That's better.
That's better. Thank you, Ms. Bell.
And Judge, on the screen share on the, it's not giving me the option to share at this point.
All right. Ms. Bell, can you hear me?
Yes?
Excellent. Go ahead and get started. I have your presentation up on the screen.
Okay, and this will allow me to share are you going to show it on the screen? Okay. Or I think I can share it from the WebEx. Can I try that? So everyone on
No, ma'am, we
WebEx-
don't have, no, ma'am, we already made the choice to put that up. The WebEx wasn't coming up immediately on that screen.
Okay.
So I will follow you on as you go through, and I'll do the clicking on this end if that's acceptable.
Okay, thank you, Your Honor. May it please the Commission, Mr. Chairman, Commissioners, and Judge, my name is Stephanie Bell, and I am here on behalf of Velvet Tech Services, LLC with Mark Ellinger. I want to start by thanking the parties and the Commission for considering and for working to accommodate Velvet's timeline. This case is fundamentally about economic growth and development in Missouri. Velvet Tech is proposing to construct a major facility in the Kansas City metro area. This facility will result in millions of dollars of wages being brought into the Missouri economy. It will create thousands of new construction jobs and a number of full-time, highly compensated jobs. Schedule MKT is a critical tool to help move this project and Missouri forward. Approval of Schedule MKT is consistent with this commission's precedent. In the new core case in 2019, this commission approved Schedule SIL. That approval allowed another major economic development project in Sedalia, Missouri. That commission approved tariff contains many provisions similar to the provisions requested here. I do want to stress the MKT schedule is a cost-based solution. It is designed to recover costs, and Velvet intends to cover its costs. Still, this is a unique opportunity that merits a unique solution. Velvet is supporting new renewable energy development to support 100% of its load to the SPP grid. And Evergy is purchasing energy from SPP to serve Velvet's load. Again, this is not just the 15% minimum in statute, but 100% renewable energy. This type of above and beyond commitment should be applauded by this commission. Approval of Schedule MKT is in the best interest of all of Evergy's customers and in the best interest of the state of Missouri. As I will discuss, the evidence and law demonstrate that this commission can and should approve Schedule MKT. Next slide, please. Allow me to discuss the project that Velvet is bringing to Missouri. Located in the northern part of Kansas City, the Kansas City metro area, Velvet proposes to construct an enterprise data center with an investment of approximately $800 million. Other states have provided the necessary rate structures to allow construction of similar data centers. Missouri has been losing out on these projects, the construction jobs and the economic growth to other states like Nebraska. Next slide. As you can see, this is a massive project with long-lived benefits to the northern part of western Missouri. It will be constructed in Platte and Clay counties and will have a number of buildings and related improvements. Next slide. To make this project work, it's like putting together the pieces of an intricate puzzle. There has to be sufficient electric power, high-quality fiber optic lines, sufficient and appropriate land, proximity to an airport, a highly skilled workforce. These items can be found in a number of areas, but in this case, it's what makes Missouri appealing, is that the project has been backed by state and local economic development support, and it is all of these pieces together with the option for a suitable energy rate that allows the project to come together. Support from economic development partners has been critical. But still, one piece of the puzzle remains: a cost base and competitive energy rate. Schedule MKT helps complete that puzzle. This tool will help this incredible project come to fruition. Not only is Velvet seeking a cost base and competitive rate, but it's also seeking a long-term solution in conjunction with a short-term solution. Next slide, please. When we're talking about a suitable energy rate, I'd like to review the pieces of the energy rate proposed. It is a cost-based rate that is designed to cover costs. It consists of three components. One, an energy price at day-ahead prices, and that will be the most substantial piece of the pricing system. Two, a customer service charge, which is designed to cover the costs of metering, billing, administration. It also accounts for increases in cost over the contract term, and the customer service charge is higher than what was previously approved in Schedule SIL. The third piece is a capacity charge. This charge will be inclusive of interconnection costs not paid up front and expected transmission costs. It also is related to the large monthly minimum demand amounts that are found in the exemplar contract attached to Mr. Ives' testimony as Schedule DRI-2. Next slide. These types of rates have been approved in a number of different states, including Nebraska, Nevada, and New Mexico. Each rate has allowed for large economic development projects to move forward and for new jobs and growth to be created. Here, Schedule MKT gives Missouri an additional tool to compete with other states. Next slide. The Kansas City Area Development Council understands how valuable this project is and has expressly noted that a new tool needs to be offered to bring these projects to our state. Specifically, the testimony of KCADC witness Jill McCarthy said, based on existing offerings, Missouri has been bypassed by developers of hyperscale data centers. For a number of reasons, Schedule MKT should be approved. You can advance the slide, Your Honor. Please, thank you. Okay, Schedule MKT should be approved. It furthers economic development goals of Kansas City and of the state of Missouri. It also furthers the state's renewable energy goals. In addition, it provides direct and indirect benefits to other ratepayers. It also mitigates risk to other ratepayers. For these reasons, the commission should approve Schedule MKT. A little more specifics on these particular items. First, as far as direct economic benefits go, Schedule MKT unlocks 1,000 construction jobs, 50 full-time jobs with an average salary of $77,000 and at least an investment in an $800 million facility. That's what's been being proposed. These opportunities don't come before the commission or the state or Kansas City every day, and when they do, the commission has the authority and the flexibility to unlock these benefits. Next slide. This project also potentially unlocks a huge development opportunity beyond just the Velvet project. Velvet will serve as an anchor for the Golden Plains Technology Park. It will aid in the development of an 882-acre data center campus and an additional $4.3 billion of investment in the northern Kansas City area. Next slide. With respect to indirect benefits, according to an RTI study, every $1 million of capital investment supports 6 jobs, and every direct data center job supports an additional 2.5 jobs. That means just this project will support nearly 5,000 jobs in the Kansas City region. The project also supports indirect benefits. Next slide, please. This includes a larger customer base, both residential and commercial. A larger customer base is in the interest of all ratepayers. It also generates additional tax base growth in the form of real property taxes, pilots, and business personal property taxes. This means more money for things like schools, police, fire, and other essential services.
Judge Hatcher, this is Commissioner Kochmeyer. Judge Hatcher. Or Mrs. Bell, can you share your slides on the WebEx, or is it only in the room?
I believe I can try.
Okay.
It's saying that I can. Judge Hatcher, I can try, Commissioner. Judge Hatcher, is that all right with you?
Oh, that's okay, Mrs. Bell.
Okay, and Commissioner, I did email these slides to the judge, and he indicated he would be able to email the slides to all commissioners.
Okay, thank you.
There are also direct benefits to other ratepayers through the renewable energy surcharge. If you go to Schedule DRI-2, attached to Darren Ives' testimony, which is the exemplar market rate contract, you see it provides the demand charge is inclusive of a renewable energy support charge that is over and above the other charges we already talked about. That charge is for the benefit of all retail customers to support the recovery of new renewable resources. These are direct benefits to other ratepayers. Next slide. This also mitigates the risk to other customers. First, the 5-year term. The commission has previously approved contracts at 10 years and in excess of 10 years. A shortened term mitigates any risks to other customers. Second, the renewable design itself mitigates risks. It insulates customers from some risk. If the company were to build its own renewables and something were to happen to an MKT customer, other ratepayers could bear the risk of that company investment. Here, the customer is bearing the risk of supporting additional renewables into the SPP grid. The rate design itself helps mitigate risk. First, the energy price at SPP day-ahead price is the largest piece, and there really is no estimating. That cost is passed directly onto the customer. Finally, as Mr. Fisher pointed out, Velvet and Evergy entered into a non-unanimous stipulation yesterday, which adds a hold harmless provision to the current schedule. That mitigates risk for other customers. I want to talk briefly about the other arguments that have been made by other parties. First, staff's testimony focused on lawfulness, but Schedule MKT is authorized by law. Section 393-150 gives the commission broad authority in approving new service offerings. Recently, staff has made arguments about the commission's limited authority in other cases and now makes similar arguments here. Here, staff argues that the commission can only proceed in a general rate case and that it must proceed under 393-355. These arguments are strange given staff's positions were opposite in the new core case and the commission agreed. Next slide. In the new core case, staff argued that the commission, that 393-355 was not the exclusive means for the commission to proceed, and the commission agreed. Next slide. In the new core case, staff also argued that the Schedule SIL not need to be introduced in a general rate case, and in the report and order, the commission agreed. With respect to, next slide, please. With respect to the RESRAM issue that staff has raised, now, in this case, for the first time, the staff argues that the commission lacks the authority to exempt a customer from RESRAM. Next slide. But as Mr. Fisher pointed out, in Schedule SIL, which the commission approved in 2019, SIL customers are exempt from RESRAM charges. Next slide. Section 393-1040 is the Renewable Energy Standard statute. There, the commission's authority in relation to the RES and RESRAM is very broad. I'll read the first line. The commission shall, in consultation with the department, prescribe by rule a portfolio requirement for all electric utilities to generate or purchase electricity generated from renewable energy resources. Basically, what the legislature is saying to the commission, we want you to make sure there are 15% of energy sales are from renewable resources. You figure out the details via rule. Again, in the first line, it says the commission shall prescribe by rule. Next slide. The commission heard the legislature and did describe the details in a rule 20 CSR 4240 20.100. There, the commission promulgated a 36-page rule under the broad authority delegated to it by the legislature. The rule makes clear that the RES portfolio requirements are based on total retail electric sales, and that term is defined in rule. Again, I'll read the highlighted portions. The RES portfolio requirements are based on total retail electric sales of the electric utility, and then underneath that, there is a definition for total electric sales or total retail electric energy usage. Here, we have a situation where Evergy and the customer are saying the new load will not only be 15% renewable, it will be 100% renewable. Zooming out for a moment, let's assume this project goes forward. When you compare energy sales before and after the addition of this customer, sales are greener with this customer in Missouri. In this case, it's not just or equitable for a customer to pay RESRAM, essentially to green 15% of a load that is already 100% supported by renewables. The commission and the parties to this, and many of the parties to this case, have previously come to the same conclusion. Next slide. The commission recently approved Evergy Schedule SSP. That's the Solar Subscription Rider. In that rider, the customer's share of renewable energy is subtracted from the energy consumed. The result is twofold. One, the customer's share of renewable if the customer's share of renewable energy covers its usage, because net energy is zero, there is no RESRAM charge. And two, the customer's renewable energy is not included in total electric retail sales as defined by commission rule. I want to go over that again. With SSP, if the customer's share of renewable energy covers its usage, because net energy is zero, there's no RESRAM charge, and the customer's renewable energy is not included in total electric retail sales. That is exactly what Evergy and Velvet are requesting the commission do here. This is consistent with the intent of the statute, with the state's renewable goals, with the plain language of the rule, and with commission precedent. Next slide. Alternatively, if the commission were to find any material difference between what it authorized in Schedule SSP and what is being requested in Schedule MKT, the commission has the express authority to grant a variance from the RES rule and could and should grant the variances as set forth in the stipulation filed by Evergy and Velvet last night and described by Mr. Fisher this morning. The commission regularly grants variances to the RES rule. For example, in 2019, in file number EO 2019-0316, when staff determined the utility missed the appropriate percentage in 1 year, the commission granted a variance to essentially let the utility make it up the next year. Here, a unique customer sought a solution that was cost-based and aligned with their corporate commitment to be 100% renewable. They are committed to supporting their load with renewables into the SPP grid, and it is from SPP which Evergy will get the capacity for the customer's load. With respect to OPC's focus on the hold harmless issue, a hold harmless has not been required before and is not necessary in this case. As we have addressed already, there are a number of factors that mitigate risk to other customers. OPC's position appears to be that contract tariffs or EDR tariffs should only be approved if they contain a strict hold harmless provision. Yet the commission has approved multiple special contract tariffs and EDR tariffs across multiple utilities, and only one ever has included a hold harmless provision. Next slide. For the special contract tariff that currently exists for Evergy, a review of that will reveal there is no hold harmless for customers being served under that tariff. Still, the stipulation includes a hold harmless provision in an attempt to balance the interests that have been presented by the parties in this case. Velvet has stated that it desires to cover its cost to serve, and Evergy and Velvet agree that the tariff is designed to cover the cost to serve any MKT customer. Consistent with those commitments, the Evergy non-unanimous stipulation presents a hold harmless provision. As the judge pointed out, many of the provisions in the two competing stipulations are similar. The only real difference between the hold harmless provisions here is that the hold harmless provision in the Evergy stipulation expressly allows for the company or for the MKT customer to show benefits to offset any deficiencies. This is consistent with Commission's past practices in adopting special contract tariffs, where it reviews net benefits and allows a weighing of benefits against costs. Next slide. As Mr. Fisher has pointed out, the non-unanimous stipulation filed by Evergy and Velvet last night, it addresses many of the concerns of OPC. It addresses many of the concerns of staff. As I've walked through today, it's consistent with commission precedent. It's consistent with tariffs, the special contract tariff, with Schedule SIL, with Schedule SSP. It's also consistent with the state's economic development goals and goals for renewable energy. Velvet witness Morris Brubaker is available to answer questions from the commission at 1 o'clock today. Next slide. A few comments on the OPC non-unanimous stipulation. First, the stipulation fundamentally ignores that the tariff requires a negotiated contract. The company under the tariff is not required to offer a contract to anyone. The evidence will show that the company will just simply not offer contracts if under MKT, if the commission adopts Schedule 1 as proposed by OPC. This is not a workable solution, and it's not in the best interest of all ratepayers or of the state. As Velvet has expressed, the availability of a long-term cost base and competitive rate is important. In addition, the OPC stipulation raises a new issue. I would reiterate Mr. Fisher's comments and state my objection to the introduction of a new issue with respect to PED that was not addressed in rebuttal, in surrebuttal, or in the list of issues. Without waiving that objection, I would like to comment on OPC's inclusion of a prohibition on the PED schedule for any NKT customer. Next slide, please. Thank you. With the EDR statute, it's 393-1640. In that statute, it says the discount shall be applied to an incremental load from the date when the meter was set until the date the incremental load no longer meets the criteria. It expressly authorizes the use of the PED schedule that Evergy has adopted. In addition, the statute sets forth what limitations can be placed on the EDR schedule. It says the electrical corporation may include in its tariff additional or alternative terms and conditions to a customer's utilization of the discount, subject to approval of such terms and conditions by the commission. The statute does not authorize a complete prohibition on the use of the EDR statute authorized in 393-1640. OPC's proposal to bar a future MKT customer from a short-term solution should be rejected by this commission. As consistent with the statute, Schedule PED promotes economic development benefits accruing to the state as a whole. The discount is available on a non-discriminatory basis pursuant to statute. It's available to any customer that meets the criteria. No other tariff has any similar exclusion prohibiting customers from changing tariffs. Nothing prevents a customer from being on Schedule PED and then going to the special contract tariff, or being on the Schedule PED and going to the Schedule SIL. Further, there's no guarantee from any customer served under the PED that they will pay back any discounts they receive. Availability of the Schedule PED discount was important to Velvet in its decision-making. The customer, again, needed a short-term and a long-term solution. Velvet has already applied for and received approval to take service under Schedule PED and did so before finalizing any agreements related to Schedule MKT. In addition, unlike other customers who take service under PED, Velvet has already proposed to pay a direct benefit back to other customers in the form of a renewable energy support charge. In addition, Velvet has voluntarily committed to giving up the majority of the EDR benefits. The EDR would allow Velvet to stay on the EDR for 5 years and move to the MKT tariff before it would be required. Velvet proposes to take service under Schedule PED for the first 2 years during the period of its smallest load. Next slide. In conclusion, I want to direct the commission to the support statement offered by Velvet that's attached to Mr. Ives' testimony as Schedule 3, and reiterate that we do appreciate the commission's consideration of a structure that supports economic development and opens pathways for customers to meet their own sustainability goals. Missouri really does stand at a crossroads. The commission can and should unlock an opportunity for growth and development of a gigantic scale. The opposition to this growth opportunity should be rejected as it has no basis in fact or law. Staff and OPC's positions contradict positions that they have previously taken before this commission. Approval of Schedule MKT is lawful and consistent with the commission precedent on special contract tariffs and renewables. Unlike the arguments advanced by staff and OPC, the commission has broad authority and flexibility to approve a solution like the Velvet Evergy stipulation that balances the interests of all parties. Further, the commission should approve Schedule MKT because it's not only in the best interest of the state, it's in the best interest of all of Evergy's customers. The opportunity is here before the commission for the sake of ratepayers, citizens, taxpayers, and all Missourians. We urge the commission to approve Schedule MKT. Thank you.
Judge Hatcher, are you ready for us to proceed with opening statements? This is Lewis Mills. Can someone in the hearing room confirm what's going on there? I can see Mr. Kleiser on the screen. Maybe you can give me some hand signals.
Okay, can everyone hear me now?
Judge.
Yeah, that sounds like Mr. Mills on the WebEx.
It is.
Excellent, thank you, sir. We have found our mistake. We are unmuted now for everyone. Mr. Mills, representing Google, would you please go ahead and give us your opening statement?
Thank you, Judge. May it please the Commission, this is Lewis Mills on behalf of Google LLC. Google has an interest in this proceeding because it is looking at potentially developing data center facilities that would take service under a similar tariff that is likely to be filed for the Evergy Metro service territory. For all of the reasons that Velvet has announced in its opening statement today and in the filed testimony and in the letter attached to Mr. Ives' original direct testimony, Google believes that there is a significant economic opportunity for the state and for the Kansas City area that is presented with the MKT tariff. As the testimony of Morris Brubaker makes clear, for large data center facilities to come to Missouri, to be located in Missouri, one of the requirements is an attractive electricity rate. And for that reason, Google is supportive of the efforts of Evergy and Velvet to present and advocate for the MKT schedule. There are, as both counsel for Velvet and for Evergy have pointed out, there are a number of concerns that they have enunciated with the proposals in the staff OPC and MECG non-unanimous stipulation agreement, and I agree with their objections to those provisions. And with that, I'm happy to answer any questions.
Thank you, Mr. Mills. Are there any questions for Mr. Mills? If not, we will move on to staff of the commission. Mr. Keevil, your opening statement, sir.
Thank you, Judge. May it please the commission. Let me just begin here by saying that there is, in my opinion, no reason to even consider approving this tariff other than the potential economic development impact. And I say potential because as far as I'm aware, there have been no guarantees of Ms. Bell mentioned certain jobs that would be created, or money that would be spent, or whatever. But as far as I'm aware, there's nothing to actually prevent Velvet or anyone else from not following through on what she stated. Now, why do I say this economic development would be the only reason you might approve the tariff? Well, for one thing, the tariff as proposed by Evergy flies in the face of fully distributed cost rate making as used in Missouri. So when Ms. Bell kept referring to the tariff as the cost-based rate, depends on how you define cost-based. As Mr. Fisher and I think Ms. Bell all both recognize, this proposal by Evergy is primarily an incremental cost rate. It is not the same as the fully distributed cost that Missouri uses for rate making in most instances. And for that matter, what they're proposing is not even a rate. As you heard Mr. Fisher and Ms. Bell talk, what they're proposing is certain parameters be set forth in this tariff, certain parameters be set forth within a contract to be entered into in the future, perhaps between Evergy and the customers, contract with a 5-year term and a limited period of time for the staff and public counsel and parties to review the contracts and the committee, possibly even a limited time for the commission to approve it. If you look in the tariff, they talk about 60 or 90 days. filing the contract 60 or 90 days before it becomes effective. And I think that just goes to show that this entire process has been, in my opinion, rushed. Velvet Tech, Velvet Tech and Evergy were in negotiations apparently for months or possibly even years prior to filing this proposal with the commission. And then they requested expedited treatment of the filing, and even though Velvet Tech does not expect to be taking service under this tariff until sometime in 2025. And that just doesn't sound right to me, that we have to rush through this process, as important as it is, under the circumstances. Now, another problem with the proposal, and Judge, when I say the proposal, I'm referring primarily to what Evergy originally filed. I haven't had time really to go through the non-unanimous STIP that Evergy and Velvet Tech filed last night, so most of my comments are directed toward the original filing as made by Evergy. But another problem with that is that it attempts to remove the customers on this rate from basically all riders and surcharges, several of which staff believes are required by statute. And while Ms. Bell spent a lengthy period talking about variances from the commission rule on the RESRAM, we don't dispute that the commission can grant a variance to its rule. The problem is the statute itself. I'm not aware of commission authority to grant variances from a statute. And I think if you read the entirety of the statute that Ms. Bell and put only a portion of it up on the screen and read only a portion of it, I think it's the statute that is the problem in exempting these people from the RESRAM. And keep in mind also that there are at least two different pieces to this RESRAM question, Judge. There's the, can they be exempted or are they exempted from the RESRAM charge question? And then there's also the question of whether the additional load that they impose on the Evergy system counts toward Evergy's renewable energy standard requirements in terms of how much of Evergy's portfolio has to be renewable. And I found it curious that Ms. Bell spent so much time arguing that they can get a variant, or they don't even need a variance from the requirement that the commission can just say they don't fall under it because they do, their Velvet is paying a certain amount for renewable. I find that curious when they have a provision in their stipulation, which they filed last night, requesting a variance from the rule. So if they don't need a variance, there's no reason to request a variance in their stipulation that they filed last night. I would also like to remind everyone that what we're talking about here is not just a contract between Evergy and Velvet. This tariff would apply to all future scheduled MKT customers as well, and we don't know what may be in the contract between Evergy and those customers. We don't know if those customers are going to be as willing as Velvet was to pay a certain amount for renewables. We don't know a lot of things that may be or may not be in the contracts between Evergy and future customers. So the fact that Velvet is willing to do something does not mean that all of these future customers will likewise be willing to do that. So I don't believe you can focus solely on Velvet and what they have offered to do in the contract, because that really means nothing for other potential customers on this rate schedule. As I mentioned, another problem with the proposal as originally filed by Evergy, there is no real protection for other customers. And, Mr. Fisher mentioned that, the economic development rider provision in the stipulation, which was filed by OPC staff and MECG, would kill the deal. I think it's important that you recognize why that was included, and that was because simply to serve as protection for other customers who, would otherwise wind up picking up the, or subsidizing the discounts being received by, customers on the, economic development rider tariff. I suspect Mr. Woodsmall will, address that further when he gets up here. Mr. Fisher also mentioned that, on the RESRAM issue, that the company is not required to have a RESRAM. So therefore, I guess under Mr. Fisher's argument, since they aren't required to have one, then anyone can be excluded from it. Well, that's not what the statute says really, but, his point's correct that, they're not required to have a RESRAM, but the problem is they do have a RESRAM. They chose to have a RESRAM. They weren't forced to have one. It was their choice. And now that they've made the choice to have one, they're stuck with the statutory and other requirements that, commensurate with it. The same with the, exemption from PISA that they're, trying to, receive by virtue of their non-unanimous stipulation. Mr. Fisher referred to, I think, paragraph 7 in here. Yes, in paragraph 7 of their non-unanimous stipulation seeks to exempt them from certain provisions of the PISA statute. Again, that was the company's choice to choose to elect to have PISA, and once they've elected it, they can't pick and choose what provisions they want and what provisions they don't want. You take it or you leave it. Well, yeah. As I indicated, staff hasn't really had a great deal of time to go through the STIP that was filed last night by Evergy and Velvet. But we will have witnesses available at 1 o'clock to address questions. Mr. Fortson originally filed testimony regarding the fuel adjustment clause. Ms. Eubanks filed testimony regarding the RESRAM. Ms. Cleathermos originally filed testimony supporting the revised tariff that staff submitted. Unfortunately, Ms. Cleathermos has resigned her position at the commission and taken the job elsewhere. So, Mr. Fortson, not Mr. Fortson, Mr. Bush will be adopting her testimony and will be available to answer questions. With that, Judge, when I say we as a staff, and I hopefully believe Public Counsel and MECG, ask that you would adopt the tariff attached to the stipulation filed by the three of us, because that contains what we believe to be the necessary consumer protections required under a tariff of this nature, as well as recognizes the legal implications. If Evergy tariff is approved, it's not clear, but I certainly believe it's their intent to exclude customers on this rate from all surcharges and riders, not really just FAC and RESRAM, but they would exclude customers, I believe, from any future securitization charges, possibly even tax charges. I mean, it's really pretty wide open what they seem to want to exclude customers from. It's like if it's not in the contract that they will execute, and we don't know what terms are really going to be in those contracts. If it's not in those contracts, then the customer wouldn't pay it, and we don't believe that would work. So with that, Judge, I will stop and take any questions you might have.
Thank you, sir. Are there any questions? Hearing none, we'll go ahead and go to Mr. Kleiser for the Office of the Public Counsel.
leave these with you.
Thanks.
Take them, throw them away. You want? This on? I can't tell. I'll just project. If it would please the commission. John Kleiser, on behalf of the Missouri Office of the Public Counsel. I want to start off by saying this is a bit of a weird case. And it's a weird case because, you know, most of the time, you got one party coming up saying, commissions don't do X. The other party coming up saying, commissions do X. Well, here, all the parties are basically saying, yeah, commission, go ahead and put the special market rate tariff into effect. There's just a slight disagreement on which tariff. And as Judge Hatcher, you pointed out at the beginning of this hearing, there's not actually a whole lot in disagreement, actually. The two tariffs, if you compare them side by side, have a lot in common. And that's really a good thing. I mean, I think that the commission should be happy that the parties were able to work together, were able to get so much agreed to before this, and that we were able to narrow this down to such minute changes. Now, that being said, there are still a few slight differences that need to be addressed. Now, there are two that are near and dear to the OPC's heart. Those are the two I'm going to focus on. That's not to exclude the other ones. Those are important too, but I want you to just focus on these two. And those are the inclusion of an explicit hold harmless provision and a mechanism to deal with the RESRAM. Now, as that first one, you're thinking probably, but wait, counsel for Evergy, counsel for Velvet Tech, they said they do have a hold harmless provision, right? Wrong. Their hold harmless provision isn't really a hold harmless provision. And the reason for that is, while they have a sentence that says, yes, customers will be held harmless for any revenue deficiency, they immediately follow it up with a sentence that says, but we expressly recognize that the company has the right to present evidence if the commission's consideration of other economic benefits. All right, what is this and how is this supposed to work? Well, I'll give you a quick example. Evergy signs a contract with Velvet Tech. We'll just use them as the example. Unfortunately, the contract price doesn't cover the cost of serving Velvet Tech. There's a revenue deficiency. Normally, that revenue deficiency, if there's a true held harmless, is going to have to be settled between the company and Velvet Tech. Other customers aren't going to pay for it. But with this line in here, what Evergy is going to do is they're going to come back and they're going to say, all the other customers should pay for that revenue deficiency because this company brought other benefits or something like that. So it's not really holding harmless the other customers for the revenue deficiency. It's providing an out to Evergy. And that's what the OPC is trying to avoid. In fact, if you remove just that sentence, what's in the OPC staff MECG non-unanimous stipulation tariff and what's in the company Velvet, I keep saying company, that's going to be confusing, Evergy Velvet Tech tariff are almost identical. There are some wordsmithing changes. There's some differences, I'll admit. But the core principle is nearly identical if you remove that one sentence. And I want to make it very clear. What the OPC is asking for is, at heart, really nothing more than a direct adoption of the language that already exists in Evergy's SIL, which stands for Special Incremental Load Tariff. This tariff, I don't want to be too oblique here, but it was effectively created more or less to serve Nucor, which you might have heard referenced earlier. It is a tariff that's specifically designed to allow for special contracts like the kinds that are in this tariff. In fact, in her rebuttal testimony, witness for staff, Ms. Robin Cleathermos, told the commission, you don't even need the MKT tariff, you already have the SIL. Now, Evergy has responded that no, we need the MKT, and I'm not here to argue that point. What I am here to say is, all we're asking for is to take the language that already exists in one tariff, that Evergy already agreed to, and to pretty much copy and paste it into this tariff, changing only really the names. And you can see this if you look at the handout that I provided. Effectively, at the top, you'll see what's in the SIL tariff, and at the bottom, you'll see what Ms. Mansell proposed in her rebuttal testimony, which is really basically the exact same thing with some names switched around. So, at the end of the day, all that we need for the hold harmless is pretty much the exact same language that's already in the SIL. I just want to pause for a second, because the counsel for Velvet Tech suggested that a hold harmless has never been required. I think that the fact that it exists in the FIL tariff proves that wrong. I mean, it's in every one of these tariffs. So we're not asking for anything new. The other thing I want to point out is, why is it so important to have this kind of hold harmless language? And the answer to that is really quite simple. You need to think about how these special contracts work, right? You have a company, Velvet Tech, who's coming to negotiate with Evergy. Now, the company, Velvet Tech, obviously has a desire to keep its costs as low as possible. So they have a strong impetus to say, we want the lowest rates we can go. Evergy stands to profit from the arrangement because they're going to build to meet the capacity requirements of serving this new company. They're also going to build out distribution, et cetera. But does Evergy have a reason to get as much as possible in rates from Velvet Tech? If you don't have the hold harmless, the answer is no, because any deficiency can be just pushed off to the other customers. If you do have the hold harmless, however, if you say to Evergy, any deficiency is something on your head, Evergy suddenly has a strong reason to make sure that they're negotiating correctly with a contract that will cover all costs. That's the basic reason we want the hold harmless, which, like I said, is at heart really nothing more than a copy and paste from an existing Evergy tariff. And if you remove the sentence regarding their ability to come in for other benefits from what Evergy and Velvet Tech have proposed, you have in principle what the OPC staff and MECG have put forward. All right, moving off that issue, let's talk about the RESRAM. So, I want to start at a very high level just to make sure we're all on the same page. There's a RES statute. It says the company will procure so much of its energy from renewable sources. The amount is based as a percentage of retail sales. If Velvet Tech or any other company who takes under this tariff qualify as retail sales per the statute, that will increase the amount of renewables that Evergy will need to have to meet the statute. If Evergy has to buy or build to meet that increased renewable demand, they will incur costs. The whole issue is simply this: how do we ensure that Velvet Tech or any other company who takes under this tariff pays their fair share of any increased RES compliance costs? There are several available options, and if you look at the back side of the handout, you'll see I've kind of laid them out. You have one from the testimony of Lena Mansell, one from the testimony of Sarah Eubanks, Morris Brubaker on behalf of Velvet Tech put forward one, and then you have the two at the bottom that came from the two non-unanimous stipulations. I'm just going to focus on those two. And actually, really, I'm just going to turn to the one that Velvet has put forward. So what Velvet has put forward, which is fairly unique, effectively says if the company who takes under the tariff has enough renewables to meet their obligations, they're not going to pay for the RESRAM. And in addition to that, we're going to subtract their renewables, effectively, from Evergy's retail sales for the RES compliance. Here's the problem. If you ask me personally, I don't think that's legal. And I think the problem comes with the fact that you're going to have to use the plain and obvious language in the RES statute. And counsel for staff basically said the same thing. But their proposal would solve the problem in as far as it would mean that there was not increased RES compliance costs passed on to other customers. And I'm going to be very frank with the commission. For that reason, I'm not sure that the OPC would pursue a legal challenge if the commission went with what Velvet Tech and Evergy are proposing. Now, Ms. Counsel for Velvet Tech have laid out in short their legal argument for why they think the commission can do this. And I expect they'll cover it more in briefing. Ultimately, I think it's going to be up to the commission to make a judgment call on whether or not they think that's legal. If the commission says, no, we don't think we can reduce retail sales for whatever reason, the alternative is what the OPC staff and MECG have put forward, which is quite simply to say, look, as long as you cover your costs of RES compliance in the contract that you agreed to, you're not subject to the RESRAM. And to its credit, Velvet Tech has already said, well, we intend to pay a certain amount for renewables under the contract. So this should work out. Like, it all should be gravy and we don't have any problems. But at the end of the day, like I said, you have several competing options. I personally don't think what they have proposed is legal, but ultimately it's going to be the commission that has to make that determination. All right. Now, there were a couple other issues that have been thrown out. The EDR, for example, I'm going to be frank, I don't think that I am the best person to speak on that, especially when I'm about to be followed up by Mr. Woodsmall, who is, I'm sure, going to do a fantastic job explaining why the EDR provision that's in our tariff needs to be there. So I'm going to let him handle that one. There's also a question regarding securitization. That was touched on very briefly by Mr. Keeble for staff. That is a problem. You'll find in the OPC staff MECG tariff, there's a line, and I can point it out more specifically if you request, that basically says customers will bear any future surcharge, including, for example, securitization. That's meant to address that problem. Outside of these, or maybe a couple more issues, we are really, really close. And I hate that we have to be here. I think everybody on both sides worked really hard to avoid this hearing. It's unfortunate, but it is what it is. I will say this in closing. What the OPC staff and MECG have put forward has attempted, truly attempted, to hit every single one of the major goals of what Velvet Tech and Evergy originally proposed. For example, the three-part rate, boom, that's in there. The having a rate set by SPP prices, that's in there. Exclusion from the FAC, that's in there. A way to avoid the res ramp, technically that's in there. If they can pay it through the tariff, they don't have to pay the res ramp. We are making a good faith effort to make this work, and I hope the commission recognizes that for what it is. Other than that, I'll simply ask 30 questions, and if not, I thank you for your time.
Thank you, Mr. Kleiser. Are there any questions for public counsel? Hearing none, we'll move on to MECG, opening statement by Councilor Woodsmall. The floor is yours, sir.
Thank you, Your Honor, and I sent you the PowerPoint, and I hope you have sent that on.
I have.
Okay. Remember when I used to be able to do this without reading glasses on? Good morning, David Woodsmall on behalf of Midwest Energy Consumers Group. As you know, MECG represents the interests of large commercial and industrial customers before the commission. In this case, MECG represents the interests of approximately 50 large Evergy customers that are concerned with the structure of Evergy's proposal. It is important to recognize that the parties stand and where the parties stand in this case. While Evergy and Velvet claim that the tariff is in the public interest, the industrial customers, the residential customers, all the customers, and the entity responsible for providing an objective opinion, the staff, they all disagree. All three of those, every customer group says that this is not the public interest, that it is harmful for current customers. As an initial matter, I want you to think about why Evergy needs this tariff. Evergy states that it needs this tariff to attract these mammoth 100 megawatt customers in Missouri. What is implicit in that statement? Think about that. We need this special contract to attract customers. The obvious takeaway from Evergy's statement is that its current rates are so high and so uncompetitive that they can't attract these customers on their own. The same rates that everybody else is subjected to isn't good enough to bring in business. So they need something special. So instead of using its collective brain power to find ways to make its current rates more affordable, Evergy instead devises schemes like that before the commission today. Schemes that intentionally seek to avoid statutes and the consumer protection mechanisms in those statutes, and instead pushes the edges of regulation simply to inflate its own corporate profits at the expense of its current customers. And I'll show that all to you. In the course of this case, staff OPC and MECG have identified several aspects of the proposal that are detrimental to current customers. I'm going to address the two largest detriments in my mind. It is important, however, to recognize staff, OPC, and MECG are not. They are not against economic development. Heck, given the nature of the customers I represent, I have to factor in economic development. But economic development can't simply be done with blinders on. It needs to be done with specific intention to ensure that current customers don't suffer. Giving Velvet or Google the special rates and the special conditions contained here today, when it means that other customers already saddled with uncompetitive rates, if they end up closing and employees go unemployed, what have we accomplished? So don't do economic development with blinders on, as Evergy now asks you. With all this in mind, OPC and MECG executed a non-unanimous stipulation that we believe fixed many of the problems with the MKT tariff. With the tariff changes incorporated into that tariff and discussed here today, staff, OPC, and MECG all agree that this tariff can be approved. I mentioned earlier that with this proposal, Evergy is seeking to avoid statutes and consumer protection mechanisms. This is what I'm talking about. There's already a statute in place to attract customers like this. Section 393.355 gives the Commission the authority to approve rates outside of a rate case for a 10-year period. That is important because the rate is locked in. You can effectively bind future commissions by using this statute. That statute is applicable to any new load in excess of 50 megawatts. But there's a catch, and this is the catch that Evergy doesn't like. There is a provision in there, a consumer protection provision, that says the Commission must also approve a tracking mechanism for net margins, such that a utility's, quote, net income is neither increased nor decreased. So there's a statute that gives the Commission the authority to approve rates to attract these customers, but it says that the utility can't make money off of it. That any profits derived from that have to go back to the other customers. Well, if they can't make money off of it, you can bet Evergy won't do it. It is this consumer protection tracking mechanism that leaves Evergy scrambling for other alternatives. Given that Evergy is not allowed to realize either an increase or decrease in net income, any additional profits associated with these new customers go to the benefit of legacy customers. Since it doesn't like that fact that profits go to these customers, Evergy schemes and plots to come up with a method to attract these customers, but also to allow them to keep all the benefits. Schedule MKT is their proposed method. And there's two parts to this that you need to understand. This is as complicated as it gets. You know, I've been doing this 30 years, and it took a long time delving into this. This is tough stuff. So you have to really pay attention to how the individual parts work together to see where the detriments are to current customers. Under this plan, Evergy intentionally sacrifices its current customers already saddled with uncompetitive rates, so that it can attract these mammoth customers, enjoy huge amounts of profits. As I noted, the MKT customer wins, Evergy wins, legacy customers lose. So let's talk more about how Evergy's scheme works. There are two parts, as you can see here. The first part, in order for Evergy to make these profits, they need both of these parts. So first, Evergy proposes to serve the new customer under the large power tariff with the 40% discount provided by Section 393.1640. So these customers are coming to Missouri, but they're not immediately going on to the MKT tariff. They are going on to the large power tariff with the economic development discount. Then, prior to the end of those 5-year discounts, Evergy will migrate the new customer to the MKT tariff sought in this case. Both of these steps provide harm to customers, but let's look at the first one. Section 393.1640 provides for a 40% discount to any new customer with a load of 300 kW and a load factor of 55%. This is an important part, however, there is an important part, however, that the utility doesn't absorb these discounts. Instead, the statute specifically states that the other customers are responsible for these discounts. So envision what's happening here. A new customer comes in, they get a 40% discount. That new customer's happy, discounted rates. The utility's happy because even though they're given a discount, all the other customers are picking up that discount. So the utility's getting all its profits. So initially, other customers are getting harmed because they're picking up these discounts. And the bigger the customer, the more those discounts are in nominal dollars. The rationale behind the 393.1640 discounts is fairly obvious. It's nothing more than a loss leader. It attracts new customers to the system by granting a 40% discount for 5 years. So the 5 years, the new customer is happy because it is receiving the discounted rates. Utilities made whole. All the other customers are left holding the bag. This is the loss leader because the legacy customers are sucking up these discounts. So in reality, after 5 years, though, the legacy customers get their end of the deal. That's the quid pro quo. We're giving the new customer a discount up front, but after 5 years, that new customer is paying full rates. So they're sucking up some of the cost. So the quid pro quo, new customer gets a discount. After 5 years, they're paying their full amount. The legacy customers will have lower rates. But that's not what's happening here. Here, Evergy has created an evil scheme that seeks to prevent the legacy customers from ever seeing the benefit of these new customers. Evergy lures these new customers to the service area with the use of these discounts, as well as the eventual migration to the MKT. So initially, the new customer will receive a discounted rate under 393.1640. The new customer wins. Evergy wins with a new customer and a higher profits. Legacy customers lose because they're left holding the bag. Like I said, under the initial discount mechanism, 5 years, the customer gets a discount. After 5 years, they pay their full freight. We miss out on that because they get the discount, and then right before regular customers, legacy customers, are to get their benefit, Evergy's going to move them out and move them on the MKT. We never get the benefits of these discounts. How much are we talking about here? 100 megawatt customer, how big is that? It's the size of 100 Walmarts. It's the size of like 40 hospitals. These are mammoth. These are bigger than any customer that Evergy West or Evergy Metro even has. These are mammoth customers. And as the size goes up, the amount of discounts and nominal dollars go up. So a 100 megawatt customer using an 85% load factor would usually have an annual bill of approximately $45 million. Therefore, a 40% discount for this customer would be as much as $18 million a year. That is $18 million a year that Evergy is wanting all the other customers to have to suck up. That's $18 million a year that other customers will have to eat without ever getting the benefit of this customer paying full tariff rates. So that is the scheme. Evergy wins because they get a new customer in at higher profits. The new customer wins because they get a discount and then onto the MKT tariff. But legacy customers don't get their quid pro quo. Here is an attempt at a graphical representation of what happens. In the first phase, like I said, Evergy wins because of the higher profits from the new customer. You see that here, win, increased profits. The new customer wins because they are receiving the discounted rate. The legacy customers, however, lose from paying these rates. But then we get over to the second part. when they migrate that customer to MKT. Evergy gets less of a win. They're getting something because they built some facilities, they're getting some profit. The new customer is now getting a huge win because they're on SPP. The legacy customers, while they lost in the first phase from the discounts, they're losing again because they're left holding the bag for these discounts, and they never got the opportunity for these mammoth customers to pay full freight rates. They also lose because, as I'll talk about, they have to ensure that incremental costs are being paid by these customers. They have to make sure there's no free ridership associated with these customers. It's a lose, lose, lose all across the board for legacy customers. Given this, staff, OPC, and MEG have proposed a simple provision. It's very simple. The commission, by statute, can't preclude these discounts. They're in a statute. The commission can't say we're not going to do it. So if these customers want to be on the LP tariff with a discount, they have to get them. What we're asking for is not to limit the discounts. We're simply asking you to put an availability provision that says if you're a customer and you've accepted these discounts, that you can't move on to this tariff for a period of 5 years. What that does, that gives the legacy customers the opportunity to get the benefit that they were promised under these economic development rate discounts. Bottom line, MECG does not oppose the MKT tariff. I think it is a valuable option to have out there to bring in economic development. So we do not oppose it. The only problem is Evergy's insistence that this tariff be linked to the customer's use of their LP tariff with the discount. Do the MKT tariff. Do it. It's great. Just put the customers on there. Don't make them migrate through an LP tariff with these discounts that simply inflate the utilities' profits at the expense of legacy customers. Attract these customers, get them on the MKT tariff. The MKT tariff itself, I'll move over this quickly. We have a provision in there to ensure that the customers on the MKT tariff pick up all of their incremental costs. So if they come on there and a cost is incurred, they need to pick that up. But the other thing is, there needs to be recognition of cost already being incurred by legacy customers to prevent them from being a free rider. So this is in the stipulation, and when we talk about that at one, I'll point this out. So this is just necessary to make sure that legacy customers don't pay any more than they should. And I kind of given a chart here on when you talk about energy, you know, legacy customers are saddled with Evergy's aged generations. MKT customers get to use SPP for its energy. Legacy customers are saddled with Evergy's aged facilities for capacity. That's not what's going to happen with the MKT customers. MKT customers are going to be given capacity either through a bilateral contract or Evergy procuring something at least cost options. We're not, legacy customers aren't guaranteed least cost because we're saddled with these facilities. So renewable credits, that was talked about a lot. Evergy has excess renewable credits now. To the extent those are used for a Velvet or a Google or ABC, whoever it is, make sure we get paid for those. Customers paid for the facilities that generate those RECs. So don't let them ride on that. Don't let them be free riders there. Stuff about transmission facilities, utility overhead. Talked about all this. Public counsel and staff talked about RESRAM. Staff has talked a little bit about only allowing this for transmission voltage customers. There was talk about a need for 90 days to review the special contract. Bottom line, approve the MKT tariff. Just Don't bury your heads in the sand. Don't do it with blinders on. Do it with intentional focus on how will this affect legacy customers. And in that regard, do not allow customers to impose these discounts on legacy customers and then immediately migrate to the MKT, thus denying legacy customers the value that they should be getting. Thank you.
Thank you, Mr. Woodsmall. That wraps up our opening statements. As I discussed at the very beginning, due to our competing stipulation tariff languages, the commission is going to take a break until 1 p.m. We're going to recess until 1 p.m. With the purpose of allowing the witnesses some time to get familiar with the two schedules, to be prepared to discuss the differences and why they agree or don't agree. Are there any issues before we recess until 1 p.m.?
Your Honor, when you say the witnesses, MECG did not have a witness. Will it be able to make comments in response to those questions, since the tariffs are a legal document and the reasons why provision may be in there?
Off the top of my head, my first answer would be that would be in the briefs, but I see your challenge in wanting to address it as it goes on. Let me put my thinking cap on, and I'll think about that. If you all would do the same, we'll try and come up with a solution.
Thank you.
Yeah, Your Honor, this is Roger Steiner. We would object to that. He's not available for cross-examination. He's not sworn.
I'll make myself. Honestly, if you want to cross me, Roger, you can.
We'll stop there, and let's all just put our thinking caps on. We'll see what solutions we can come back with at 1 o'clock. Anything else before we go on a break? Excellent. We are adjourned until our recess until 1 p.m. Thank you all. The hour of recess having expired, let's go back on the record. It is 1 o'clock. This is Regulatory Law Judge Charles Hatcher presiding over the case designated EO-2022-0061, a special tariff request from Evergy, Missouri West. Before we begin, I want to flesh out a little bit of our plan for this afternoon. I had stated earlier that the commission is going to have some specific questions, and we are going to go through the tariff line by line. I was speaking metaphorically. We're going to have the same standard hearing operation. We will call witnesses in the order which was produced by the parties. They will, in turn, introduce their pre-filed testimony. We'll go through cross-exam. When we get to those particular witnesses who would have substantive answers on the tariff, we'll just go through our normal process. And I am just looking to get those questions asked on the record. So it doesn't matter to me if I ask them or if someone asks them before me. I'm just looking to get witnesses to answer why their provision is in, why the other provision shouldn't be in, and vice versa for witnesses regarding the opposite side's proposed tariff. So with that, let me go ahead and make sure I have all of my counsel online. Mr. Fisher, are you on our WebEx? Mr. Fisher, if you're on the phone, it is *6 to unmute.
Yeah, Judge, I'm not on the phone. I'm sorry, I was out of the room.
Nope, that is fine. And Mr. I'm sorry, and Councilor Bell, are you also on the phone? Or on the WebEx? I just want to make sure you're available. Okay, thank you.
Yes.
I have talked to our background office staff, and they assure me that the ability to share your screen is now available. And this is for all of the council. We now have the WebEx showing on the witness stand monitor, which if you look on your WebEx screen, you'll be able to see that. What that does for us is it helps the court reporter, but also it allows those of us physically in the courtroom to see what a counsel or a witness would like to share on their screen in WebEx without having to look at the very tiny picture that is now in the WebEx, the camera view of the screen. Sorry for the long-winded explanation, everyone. Let's get to our first witness. By my list, that is Michelle Hathaway, who will be adopting the testimony of Mark Stombaugh. Is that correct? Ms. Hathaway, please speak up, and I'll get you sworn in.
Judge,
Yes, go ahead.
This is Roger Steiner with Evergy. Apologize. I was under the impression that we would start with the witnesses that knew about the tariff, and Ms. Hathaway is not one of those. She is traveling in the car, and I can call her and get her so she can appear now, or we could possibly take her tomorrow starting at noon, whatever your preference is. But I apologize, she's not listening in right now. I need to notify her if we want to talk to her.
No, please, let's go ahead and we will drop her to tomorrow. We already had Ms. McCarthy scheduled for tomorrow. Let's move to Mr.
Maybe
sorry, go ahead.
Maybe I'd ask right now if parties have questions for these two witnesses, we could figure that out if they do need to appear tomorrow.
I'd prefer to wait until the end of today to find that out.
Okay.
Okay. So the first witness I have then, Ms. Bell?
Your Honor, one other preliminary matter. We had made a request to have a copy of all of the documents and anything that was shared in opening statements this morning. And so we would like that ordered that anything shared this morning be shared with all the parties.
I don't think we need to order that. If you don't get copies by tomorrow, just bring it up, Ms. Bell, and I will email the copies I received.
Okay.
Your Honor, I apologize. As a preliminary matter, would it be permissible if I were to offer this demonstrative? And I ask that just for the purposes of facilitating discussions on this topic.
Right. Ms. Bell, I think that takes care of our conversation. I want to move to Mr. Kleiser's email. That was emailed to the group of us, and Mr. Kleiser purports that this is I'm going to call it a redlined version comparison. But upon talking a little bit more, what I believe Mr. Kleiser is going to do here in just a minute is he is going to offer this as a demonstrative so that all of the witnesses can then use that, and then we will circle back at the end of the day to then see if we want to offer his emailed version into the record.
For the record, I just want to explain exactly what it is and how it came about, really quick.
Okay.
What I did, I developed this. I pulled the PDF version of the stipulation that was filed on behalf of Evergy and Velvet Tech from EFIS. I converted it from a PDF into a Word document. I did my best to accept the changes that had been made because they were in red line in the version that was filed in PDF. And then I used Microsoft Word's comparison tool against a Word document version of the tariff that was filed by the OPC staff at MECG. So all of the changes that are in here are computer generated by Microsoft Word by just feeding two documents into it, and then it does the rest. I attempted to verify that all the changes were accurate. I'm not going to say for certain because I didn't actually hand do it. I would like to offer it solely just so that people can more easily identify what changes they're referring to. I don't necessarily need it in the record, although I think it might be useful to point to in briefing as just a way of clarifying what the changes are, but I'll withhold the request to actually offer it until the judge would like to take it up. For reference, though, I would offer it as OPC 202, so people can refer to it that way.
Okay. Does anyone have any objections to, at this moment, just the use of demonstrative 202?
Judge, this is Lewis Mills. I don't have any objection to using it in the hearing. I do think that, and I think it was a great idea to come up with this, but I think between now and when we're actually filing briefs, we can come up with something that is not quite so messy, that more accurately and more easily identifies the changes between the two documents. So as I said, I don't object to using it during the hearing, but I think I think it would be helpful to all parties and the commission to have a cleaner version of this document for us to use when we get to the briefing phase.
I have no objection to that, and I do apologize for the rough nature of it. It was a rush job.
Okay, what I'm hearing is that we are all on the same page, that this is a good start, and we'll see where we're at the end of the day. With that, let's call up Mr. Bradley D. Lutz. Mr. Lutz, I see you are on WebEx. If you could speak up so you'll pop up to the top of the screen, and I will swear you in before your testimony.
Good afternoon.
Thank you, sir. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you. And Evergy, that'll be your witness.
Thank you, Judge. Mr. Lutz, would you state your name and address for the record?
My name is Brad Lutz. I work at 1200 Main in Kansas City, Missouri.
Are you the same Bradley D. Lutz that caused to be filed in this case, sir, rebuttal testimony?
I am.
And I'll let you know that that's been marked as exhibit number 6.
Okay.
If I were to, do you have any changes or corrections that you need to make to that testimony?
I do not.
If I were to ask you the questions that are contained in that document today, would your answers be the same? And are they true and accurate to the best of your knowledge and belief?
They are.
Judge, with that, then I would move for the admission of exhibit number 6 and tender the witness for cross-examination or questions from the bench, however you'd like to proceed.
Thank you, Mr. Fisher. Are there any objections to the entry of exhibit number 6, the sir rebuttal testimony of Mr. Lutz, onto the hearing record?
No objection. Would it be possible for the court to turn up the volume on the speaker in here? Thank you.
Thank you. Without objection and the speaker volume being turned up, the exhibit is so admitted. That is exhibit number 6. And I believe, Mr. Fisher, you tendered the witness. So on to cross-examination for Mr. Lutz. First, we turn to Ms. Bell.
Thank you, Your Honor. Mr. Lutz, you have reviewed the OPC's Schedule 1 as compared with Evergy's Schedule 1, correct?
I have.
And you would agree that the two schedules differ on several key respects?
They do.
What are those respects?
Well, probably the most meaningful would be that around the hold harmless language and the treatment of the RES compliance and ResRAM would probably be the most prolific. Then the EDR provisions, and then there would be a number of smaller changes.
Okay, and you would agree that Evergy does not support the OPC language on the hold harmless issues. Is that correct?
That is correct.
And why?
Allow me to turn there just for a moment. First of all, the language that has been presented is largely copied from the company's SIL tariff, and we believe, to begin, that these two rate designs are inherently different, and that the conditions that underlie the SIL are not applicable or not the same for the high load factor or the schedule MKT rate. Further, there are a lot of other situations, we call them benefits, that we think need to be considered in the event of any kind of detriment that might be determined under this rate, that we think needs to be considered under the full weight of the commission review.
Okay, you would, Mr. Lutz, in your sir rebuttal testimony, you indicated that there were that the company accepted many of the changes proposed by OPC and staff witnesses. Is that correct?
That is correct.
So other than the differences you have already determined, would you agree with Mr. Kleiser's statement that that there are substantial similarities between the two stipulations?
Certainly, yes, I would agree with that.
And with respect to the other differences, would Mr. Ives be in a better position to respond to differences in the tariff?
Yes, especially on some of the items that I would characterize as maybe being more of a policy implication. The hold harmless being a perfect example. That being reflective of the corporate position. He would be very uh, appropriate to address those questions too.
Okay, so with respect to the changes to the OPC changes to the EDR offering hold
Mhm.
harmless and ResRAM, which you identified, those are all issues witness Ives can speak to.
Yes, I would offer that he would be able to provide the more corporate policy view of those. I could speak to more of the mechanics if that were a differentiation that you might wish to explore.
No further questions, Your Honor.
Thank you. And Mr. Mills, any questions?
Judge, I believe that since Mr. Lutz identified Mr. Ives as the more appropriate person to ask questions of those, I will hold any questions for Mr. Ives. So no questions.
Thank
for this
you.
witness.
And Mr. Whitsmall.
Yes, very briefly. Mr. Lutz, can you hear me?
I can.
Good afternoon, sir.
Good afternoon.
Just real quick, you mentioned the comment, I think somewhere along the line, that in a future proceeding, the commission should be able to consider, I think you call them intangible benefits. Do you recall that statement?
Yeah, I meant something equivalent to that. Yes.
Okay. You've been doing rate making for quite a while, haven't you?
I have.
And, well, how many years have you been doing rate making?
Oh, roughly about 18, I believe.
Okay. And in 18 years, can you think of any instance in which the commission has considered intangible benefits in setting rates for a customer?
I can, but if you allow me a little bit of a liberty there, I mean, I think in my view, I see those intangibles as being kind of I use the phrase policy, but maybe I use that as a blanket term for those items that are beyond the quantitative analysis that we traditionally offer in a rate design proceeding. The best example that comes to my mind would be around the customer charge, just even in a residential rate. I would offer that we're generally able to present analysis that shows that customer charge might be a certain number, but it's not uncommon for the commission to weigh other factors and choose to set that rate at some value that is different. So at least that's one example that comes to mind of a place where other factors are brought into mind to determine the final outcome of a rate design.
But would you agree that to the extent that the commission keeps a residential customer charge low, that cost responsibility is still kept within the residential class and their energy charges? Is that correct?
Yeah, I think that's fair.
Okay. And if, because of intangible benefits, as you call them, the commission decides to set rates for these MKT customers in one manner, would those would offsets be kept within that class, or could they be dispersed to other classes?
I suppose they could go to other classes. I mean, the equivalent there I would offer comes through potentially some of the allocation work that we do in our general rate designs. Although I appreciate what you're trying to say as far as containing costs. To be truthful, there are a number of generalizations that take place in the exercise of rate making, whether it be through allocations, assignments, those kind of steps that make that an imperfect process. But conceptually, I support what you're saying is that there's intentions of trying to retain costs to certain categories of customers, but I think we fall short of perfection in that regard.
But just to get to your initial premise was, it may be difficult for the commission to do exact rate making for this customer, therefore the commission can consider intangible benefits, as you call them.
Right.
That's
In
what
yes, and in this situation, I mean, I think the context is very important that if this were to occur, if this consideration were to occur, then it's only after there's been some contention of a detriment that's occurred. Then it's at that point that we're wishing or asking the commission to take that more full view and make sure that we're not just looking at a very constrained set of accounts, for example, but instead looking at the full benefit or the positives associated with that customer being present. That the constraint of accounts or certain limits like that may not give the commission a full view of what that customer has brought to the company, to non-participants, to the region. All of those things, I believe, are factors that the commission should bear in mind before they make an assessment on what to do if a detriment occurs.
Would you agree that there are other industrial customers that may provide similar intangible benefits in the area?
Certainly, and you know,
Would you agree that other industrial customers would likely employ more than the 50 employees that Velvet is discussing in their testimony?
yes, I would certainly believe that.
Do you know of any instance in which those industrial customers that employ more than Velvet, that offer intangible benefits, are given similar considerations for intangible benefits?
Well, I don't. First of all, I think that the condition that we're talking about that triggers this might not have a clear genesis with those other customers. I don't know that we have a detriment situation that we're trying to resolve to introduce those benefits.
Well, would you agree that in the mind of those customers, a residential subsidy would be a detriment?
In the mind, a residential subsidy would be,
Let me back up. Would you agree that in the mind of these large industrial customers, a residential subsidy could be considered a detriment?
Judge, I'll object. I think that calls for speculation.
Well, he's been doing rate making for quite a while. I think he can envision what parties think, especially since he's been doing class cost of service and revenue allocations for quite a while.
Well, if he knows, I guess he can answer.
I'll allow it.
okay. I mean, to begin, if a residential subsidy exists, and I would have to believe it's coming as the result of a commission order. I mean, if that's the case, then I agree that, I think that it should be allowed, or even though the industrial customer may not be happy about it, the fact that it exists and was part of a commission order, makes it just and reasonable in my mind. And although that you might not like it as a industrial customer, it doesn't change the fact that it's been weighed and found to be just.
Okay, let me just cut to it this way. In your 18 years, in all the orders you have read, have you ever seen Evergy or the commission mention the economic benefits of a certain number of employees by any customers?
The only example I'm aware of would be the proceeding that we held for Nucor under the SIL, where the economic development benefits, the jobs, all of those details were very explicit in that approval. That's the only one that I would offer in my history.
Okay. Now, So only in a situation where a customer is a class in and unto itself, have you ever seen that mentioned?
I believe that's fair. I mean, otherwise, I mean, customers are relying on other representation to keep their interests aligned, and then the commission weighs that as part of the record.
So for all the other industrial customers that employ hundreds of thousands of customers or individuals, none of those industrial customers are entitled to the same benefit.
Well, I mean, I think that I can't quite agree with your characterization. I mean, I think that in practice, those benefits, those sales, let's just boil it down to something simple and just talk about sales. But let's say you've got a factory X that's a large customer, and they're generating satellite companies, or they're bringing in employees to the area. All of those things do bring in sales that ultimately contribute and lower the average cost to all customers. So those benefits are finding a way through the rate making process and getting in the books, getting in the tally, if you will. Maybe not as overtly as this, but as what's in front of the commission with the high load factor rate. But I would contend that those elements are part of the overall and are not being ignored, but may not be accentuated in the same fashion.
They're not being ignored. Okay, I'll stop there. I have no further questions.
Thank you, Mr. Woodsmall. Let's move on to Mr. Keeble.
Yeah, Mr. Lutz, very briefly, regarding these intangible benefits and job creation and all this, what guarantees has Evergy received from Velvet Tech regarding Velvet Tech's job creation?
No more than what we would see from any other economic development effort. So
None.
I mean, I believe,
Correct?
say that again. I missed that. I'm sorry.
So the answer is none?
Well, I wouldn't say none. I mean, guarantee is the word that we're hanging up on. I mean, I don't know what the
Now,
provisions
that's the
are
word
that.
you're hanging up on. I would use that word very specifically. What guarantees has Evergy received from Velvet Tech regarding its future job creation?
I believe in the traditional definition of guaranteed, I would say none.
Okay. What guarantees has Evergy received from Velvet Tech regarding the length of time it will remain in Evergy's service territory?
Under the same distinction on guaranteed, I would say none.
Okay. You are or for purposes of this case, you were the data request contact person, correct?
Correct.
Thank you. Did Evergy run all of its data request responses past Velvet Tech before entering them into the commission's EASA system?
I'm going to object. Yeah, what's the relevance?
What do you say? Yeah? What's the relevance? Who are you speaking to?
Ms. Bell,
I'm objecting.
are you?
Yes, I objected on the grounds of relevance.
Yeah, yes, I know that, but it sounded like you were speaking to someone else in your room there. The relevance is to show the connection between Evergy and Velvet Tech, and whether they're really two separate parties for purposes of this case, or just operating as one.
Your Honor, if I may, I still would assert that is irrelevant. What?
Judge, go ahead. I would join in that objection, and I think there's testimony in the record that there's no affiliation at all, no, between Velvet and Evergy in this case. That's just a fact.
Judge, I think it's important for the commission to recognize how kind of Evergy was led in many respects in this case by Velvet Tech. We couldn't get responses from Evergy without Evergy receiving Velvet Tech's blessing. And I think it's important for the commission to recognize the relationship here between the two parties.
Are you saying that joint applicants, or in this case, essentially joint applicants, don't usually work together?
Well, they weren't really joint applicants, Judge, if you remember.
Right.
Velvet Tech filed an application to intervene in which I believe they represented that no party could represent their interest
Judge-
adequately.
Ms. Bell, go ahead.
Judge, if I may, under the rules required for discovery and confidentiality, if one party is going to potentially disclose the information as it relates to the other party, and that information may be confidential, then the party has a duty to not disclose confidential information of another party. So some coordination would be actually required under the rules.
Well,
I agree with Ms. Bell, and for that reason, I'm going to go ahead and allow the question. It seems like that's the normal course of business. So, Mr. Lutz, if you would answer Mr. Keevill's question, please.
Mr. Keevil, would you repeat the question just to make sure I answer it correctly?
is there any chance you can read the question?
Yep, let me find it. Did Evergy run all of its data request responses past Velvet Tech before entering them into the commission's EFIS system?
Okay, thank you.
Your Honor, I would renew my objection.
So noted. Thank you, Ms. Bell.
In answering, I would like to maybe include some of the additional detail that I heard afterwards to hopefully speak directly to your point. And I would point out, if you remember, that Velvet is our design case customer for this. So in a short answer, I would answer yes, that they were aware of the responses that we provided. Now, I would also say, though, that we were not constrained by Velvet in areas outside of confidentiality, and that was the primary concern in many of the regards where their input was sought. With respect to issues around the rate design and the tariff that we proposed, the company put forth its position in this filing.
All right, so you're saying that unless you thought a response was confidential, you didn't run it by Velvet Tech first?
Well, I'm trying to parse the run it by, because I think you're implying that we got their release or approval for something, and I would be willing to contend that we informed Velvet, but I would not say that we were restricted in any way by Velvet, except for areas of confidentiality where we deferred to their guidance on what was important to them.
Okay, and when you say area, well, you may have just answered it. When you say areas of confidentiality, could you be a little more specific there? What kind of areas are you talking about? Areas not encompassed by the commission's rule on confidentiality, or something else?
Your
No,
Honor, I would like to register a continuing objection to this line of questioning. It's just irrelevant to the issues before the commission.
Thank you, Ms. Bell. Your objection is noted and overruled. I can trust the commissioners to judge for themselves the relevancy. Please go ahead, Mr. Keevil.
I think it's a question question outstanding, Judge.
Okay. Right. In working with Velvet, it's been clear to me, whether it be through the work that we've done together, maybe it be through the non-disclosures that we've executed with each other, that confidentiality is of utmost importance to them in this process. And so it was in respect to that sensitivity, that those agreements, that deference was given on matters that had any potential repercussions in the confidentiality area. It was out of an abundance of caution that we would seek any guidance on those matters and make sure that we were not inadvertently doing something that we shouldn't.
In fact, the identity of Velvet itself is actually confidential, correct?
Yes.
Thank you. No further questions.
Thank you, and that brings us to Mr. Kleiser.
Good afternoon, Mr. Lutz.
Good afternoon.
Before we get too deep into the questions, I want to ask you just a few to make sure that the record is clear for what I'm about to discuss. So, when I refer to Schedule MKT, you would agree with me that I'm referring to the special market rate tariff that Evergy is seeking approval of, right?
I agree.
Right, and for Schedule SIL, that is the special incremental load service tariff that Evergy already has in effect, correct?
That is correct. And Missouri West, to be specific, for Evergy.
Super. I just wanted to make sure that those terms were clear for the record.
Yes.
All right. You've already had quite a lengthy discussion with counsel for MECG regarding the benefits that would come from a customer entering onto one of these two types of tariffs. Do you recall that?
I do.
All right. So to be clear, if a customer takes service under the existing SIL tariff, that customer could also provide intangible benefits to other customers, right?
Correct.
Right. And there is no explicit language in the current SIL tariff that says the company has the right to bring on evidence of those other benefits, correct?
That is correct.
All right. So in both cases, the benefits are there, but we have a change in language between the tariffs. Is that accurate?
That is correct. That is correct.
All right. My next line of questioning, relatively simple. If your language is adopted with regard to the hold harmless, do you believe third parties like the OPC or staff would have higher or lesser scrutiny of the contract?
I would hope it would be the same, irregardless of that term.
All right. I actually have no further questions. Thank you.
Thank you, Mr. Kleiser. We'll now go to bench questions. Are there any commissioners who have questions for Mr. Lutz? Reminder, if you're on a phone, it is *6 to unmute. Are there any commissioner questions for Mr. Lutz?
No questions, Judge.
Thank you. And once again, I do want to say for the record, we do have all of our commissioners here in attendance today. Mr. Lutz, I do have several questions for you. First, would you please pull up your rebuttal testimony?
I have it.
Thank you. I'd like to look at page 4, lines 14 through 18.
I'm there.
You state that Evergy intends to track all costs related to the MKT tariff customers, consistent with the Nucor case and through its FAC mechanism. Is that correct?
That is correct.
Can you elaborate on the plan?
I can at a general level, if that would be a good place to start, and then we can see if the additional detail is needed.
Yes, please.
The intent here is to take all of the costs that are coming into the company through these types of transactions and make sure that we've identified and accounted for those that are unique to these customers, and we pull those out separate, whether it be through some kind of a special code or special notation in our books and records, but something that allows us to pull those out distinctly. The Nucor experience is the best example and has been most effective in interacting with the parties, because we can point to that and show what our intentions are. And through that Nucor effort, what you would see would be just a general delineation of those costs as they're separated from those that do flow through the FAC charge. So depending on the nature of the service and the charges that we receive back through that service, that would dictate what those accounts, records, details would look like. And I would expect that because we're using the SPP aspects, they will vary a bit from what Nucor had, but still be very much in line with the spirit of what we were trying to do through that exercise.
Okay, and that really leads right into my next question. This case has been compared to the Nucor case, and in that case, Evergy committed to a power purchase agreement through wind power, which it said would be easier to isolate from other power sources for tracking Nucor's energy use. Is a similar arrangement planned here?
No, there are no renewable responsibilities by Evergy under the MKT tariff. In this scenario, the renewable attributes are brought into play by the customer. And because we're using the SPP pricing as our common element, they can bring their renewable resources into play and use them against or in conjunction with, maybe is the better way to say it, their usage at this location. So they can bring their own renewables in, manage them, bring them together through the SPP pricing, and have better control over how those resources serve their purpose with respect to their load here in the Evergy jurisdiction.
Can you explain why customers of the MKT tariff would be excluded from all riders except for the license and tax rider?
The riders that we're excluding are the ones that are currently in effect. And as we went through my testimony, we identified like the FAC, the DSIM, which is our demand side investment mechanism, also the RESRAM. And we spoke to those, and I can elaborate a little bit further on each one if you'd like, but we believe that those riders were intended for purposes outside of this character of service. And we sought to only apply those riders that were relevant to the service received by an MKT customer.
You said you could elaborate on that. Would you go ahead, please?
Sure. The biggest one is the FAC, the fuel adjustment clause. That is the largest charge I would offer. And you know, it's designed to address those fuel costs that are incurring in between rate cases. And in this scenario, we're relying entirely on the market to provide service to these customers. So many of the attributes that are collected through the FAC aren't applicable, and those that are, we've made provisions and agreements to isolate and charge through directly to the MKT customer. So the FAC is not relevant then in that regard. On the demand side investment mechanism, we think that it would not apply, but it would be through the normal opt-out provisions of that statute and rule. For those that might not be familiar, the MEEIA, the Missouri Energy Efficiency Investment Act, includes provisions that allow customers to opt out if they meet certain criteria. We believe that these customers of this class will be able to meet those criteria and will be able to exercise their normal opportunity to opt out. So in a way, we're not excluding that one, but expect that customers will exercise their rights to do so. Under RESRAM, we talked about that in our testimony in a couple of different ways, both in mine and Darren Ives. And we have a situation where a customer is bringing to the equation 100% renewables. And the way the RESRAM charge is set up to recover those costs, there are none to recover. Somewhat similar to what we saw with the SIL rate, we have a situation where there is a renewable that is in play that can address what the renewable energy standard was attempting to do, and to do it in a much stronger way than just the limitations of, say, the 15% requirement. So that led us to pull the RESRAM charge off of the applicability.
And you brought up the renewables, and I wanted to discuss a little bit something that OPC witness Dr. Mark brought up in his data response request, that renewables weren't part of this. Can you flesh that out a little bit more? You touched on it, that Velvet would be introducing their own renewables, but I'm not sure if that means their own solar fields on their land, or they're purchasing and they're paying transmission costs. Could you help me with that?
Right. I believe this to be even a utility scale purchase power type agreement somewhere in the SPP footprint. This would not be local on-site, say like rooftop generation. That is not the character of what we're talking about. We're talking about large SPP market level renewables. And maybe the distinction is the ownership of those renewables, the management of those renewables, all of those aspects of their renewables are wholly on the customer side. But what happens is, as you determine the rate and you examine the workings of the rate, you need to bring the impact of that renewable back across the line and acknowledge that it is interacting with our rate designs in a certain way to achieve an outcome for the customer. So I know that's probably confusing a few folks as far as how those interact, but I would reinforce the fact that those renewables, everything about the renewables and their physical existence, their operation, the monies paid for those to exist, all of the interaction with the SPP market of those renewables is on the customer side, and not part of what we would deal with in our execution of this rate.
Okay, and speaking of the customer side, I'd like to talk about cost of service. Would the MKT tariff customers be entirely responsible for their cost of service, including the cost of construction to serve the new customers?
Yes.
I'm going to take that as a yes to both.
Yes.
Their cost of service and, sorry to over-talk you. Thank you, Mr. Leff.
No, you're good. You're good. I'm sorry. But yeah, to both. The rates are designed to recover the cost of service to that customer. And yeah, I would agree.
Okay, I have a handful of questions left. Do you happen to have Ms. Mantle's, that's OPC witness Lena Mantle's testimony there?
I will need to open it, but I can have it momentarily.
Okay. I'll go ahead and ask my question. I'm
Please.
looking on page 3.
Okay.
Ms. Mantle suggests that Evergy West customers may have to pay additional renewable resource charges because of the increase in load from this proposed tariff and its new customers. Can you address that concern and the proposed tariff language that Ms. Mantle includes in her rebuttal?
Okay. Let's see where to begin. The issue of compliance cost. We've talked about that in opening statements from a couple of different points of view, but the issue is what to do if costs occur. And what we've tried to do in our language is to create a situation where that increase in cost that is not being attributed really by any action on the part of Velvet in this case, is resulting in a charge. As I just mentioned, they are bringing their renewables. They will have their renewables. Our language, I think, has even set up details to make sure that that is attested to or documented properly. But the point being is that their renewables will help achieve the purpose of not causing increased cost. What we're trapped against, or what the issue is the idea that their load has to be represented in the calculation of compliance. And if the company language is accepted, there's a provision way for that to be avoided, and those subsequent costs to not occur in the way that's being laid out in some of these other examples. Now, turning to Lena Mandel's testimony, her language specifically, just lays out that if there's a cost, that it should be recovered from the customers who caused that cost, and that there's not a subsidy or any recovery from non-participants. And while certainly being in spirit with what we're trying to do, we're back to that point I just made about the fact that the compliance mechanism is causing a double assessment almost, where Velvet already has the renewables, is using it in this case to make their entire load green, but simply because of the execution of the RES mechanism, there's the potential that additional costs could occur. And we're just trying to find a medium in there where we are able to achieve the intent of the compliance, RES compliance mandate, but we're not setting up a situation where customers have to pay twice, or the company has to pay twice for any step of that we find a way to acknowledge what the customer is bringing to the equation, and that we're not harming other customers in the process. It's just kind of a little bit of a puzzle due to some of the structure of the calculations for the compliance. You'll have to forgive me as a little bit of a long answer. So if I missed the point of your question, please ask it again, and I'll retry.
No, you're doing good. Thank you. My next 4 questions are going to be on the 2 proposed tariff stipulations.
Okay.
These are the same 4 questions I'm going to ask of all of the witnesses dealing with these tariff wordings. So again, I'm not concerned if I'm the one that answers these questions in the future. I'm just trying to get these on the record. First, I want to take up the OPC staff and MECG proposed Schedule 1.
Okay.
What provisions do you oppose, and would you explain why those aren't appropriate?
Okay. Yes. Allow me a moment to organize my thoughts here. I'll try to take them in order, although I may be unsuccessful there, but I will try. Our first concern is in the availability section. There's an additional provision of a second bullet that says the customer has not accepted a discount under 393.1640 in the past 5 years. That statute references to economic development riders, and I think we've been talking about that a number of times so far today. We disagree with that. We believe that those EDRs are valid and applicable in these situations. You'll even see that in our language, we've tried to meet in the middle and provide some assurances that those EDR provisions are used wisely. But the the simple exclusion of it that's offered in the other party's tariff proposal is unacceptable to the company.
Oh, okay, go ahead.
The second would be what's been deemed as the hold harmless language. That would be in the additional provision section in paragraph 4. And I believe is largely a replication of the SIL language. The first thing I would state there is that the SIL tariff was brought about in a completely distinct environment, different inputs, different considerations. Also was part of a settlement where the parties worked together on a number of gives and takes to achieve the final outcome. With this provision being a part of that. So as we turn to the high load factor market rate, the situation is a little bit distinct, and the company believes that although we're welcome to, investigate some kind of treatment if there is some detriment that derived inadvertently from this rate, that to just have a mandated equation for applying a make whole adjustment to the company without any consideration of other factors or measures is not fair. That the company should be able to look at this in its entirety and judge if there is any bearing to the other factors before just simply applying some make whole or hold harmless as we've heard it termed. So the company would reject the addition of that provision. And then you bet. And then also in additional provisions on number 7 on the RESRAM charge. One of the main concerns that we have is I'll call it the misappropriation of this renewable energy contribution charge. I think you'll find when you look at DRI 2, attachment to Darren Ives' testimony, the name is slightly different. But the point being, that charge, that amount of money was set up for a pretty distinctive purpose. That Velvet was seeking to advance renewables in our area and wanted to make a positive contribution to that. This suggestion by OPC and the others would basically claim that and use it to offset any kind of compliance cost that might come about. It's our belief that a more elegant solution is to deal with the calculation of the compliance cost as we've laid out in our proposal, and that could achieve, I think, much of the same intent of what we all are trying to do here, but just finding a way to do it through the calculation instead of I don't know, reappropriating this contribution that Velvet has offered. I would say those are the main ones. There's a couple of smaller ones I would want to highlight back in the availability. We would like to continue to offer a substation voltage option. Although transmission is certainly most applicable in our design case, I hate to constrain us prematurely on that. The substation voltage is relevant. There is reasonable reason to anticipate that there could be customers that are less comfortable owning those pieces of plant and would look to the company to address those. So I think there is some value in continuing to own or offer a substation voltage in addition to the transmission. And let me see, one last double check, and that might be my concerns. Right. I believe I would say there is some additional hold harmless language in additional provisions, section paragraph 3, that would bleed over into the mechanics that are laid out in 4.
All right, thank you. And I'm pretty sure you've already answered my next question. I'm going to go ahead and ask it just to be sure. Are there any provisions you believe should be included in the OPC staff MECG Schedule 1 that are missing?
I wouldn't say that are right. I wouldn't say that they're missing. I think that I feel like the two groups are pretty much aligned on the factors. It's just about which choice do we make to go forward. I don't know that anything's missing from either of the offerings.
Okay. Do you have any other concerns with the OPC staff MECG offering?
I think I would only offer that it might be I don't want to call it a failure. That's much too strong. But I think we cannot lose sight that there's another part to this process, that the tariff that we've proposed here contemplates a separate filing and a separate proceeding, and the introduction of a customer specific market rate contract. And it's in that proceeding where a lot of detail will be provided, explored, and vetted. And that I don't want to lose sight of that. I certainly understand the desire to get the tariff right and provide a solid foundation for those future contracts. But I also want to realize that as the commission ponders this matter before them, that there is yet another piece that will allow the commission, the parties, to get comfortable that things are appropriately structured, that rates are priced in a way to ensure recovery of costs. There's another piece to this puzzle. So I guess I would just want to make sure that visibility is kept on that fact, and that we don't get too lost in trying to make this perfect, that we hamstring the ability to bring that second part of the puzzle into play at a future time.
Thank you, Mr. Lutz. And this will be my last question for you. I'd like to turn to the Evergy Velvet proposed Schedule 1.
Okay.
Would you briefly explain the key provisions that were added? And if you want, I know that Evergy and Velvet had deleted some conditions. If you would walk us through that for the record and explaining why each was necessary. I'm aware that there might be some agreement on the deletion of some language that you might want to go ahead and mention.
Okay.
But I do want to make you aware that the commission is going to be particularly interested in areas of disagreement.
Okay.
But go ahead and Billy, please go ahead. Sorry.
Okay, will do. And maybe just to be complete, I'll largely just page through or step through the pages and try to hit the major change areas. In the availability section.
If you
Okay.
could, yes, and if you could please continue telling us the section and the paragraph number, we'll keep score at home.
Will do. First, beginning in the availability sections, there are a couple of edits there that the company is proposing. I'll start at the bottom, the third bullet, the strike on the North American Industry Classifications Code. I believe that we're aligned, all of the parties are aligned around this to remove this availability criteria. So I believe that that's acceptable, I think, to all. The one above it in the load factor, this is something that we've worked on, and I think that the parties' two views are very close. There's just some subtle differences in the words. I think that kind of introduce the elements, but the key factor here is we want two provisions for this definition of load factor. We want to recognize that customers will have a certain load factor when they're in a steady state, and then we want to acknowledge that during periods of growth, during their initial startup and or what we call ramp up, that we have a different measure of that load factor. Just mathematically, there's some problems when you have a growing load. When you calculate load factor, you can actually show a reduction in that load factor because of that growth. So what we've got, and the key word, and admittedly it's present in both versions, so I'm comfortable with both, is the word average being associated with annual load factor for the ramp up periods, and that is present in both of the proposals before the commission. I've already spoke to the voltage, the substation transmission voltage issue, so I won't replicate that here. I would probably move then to the rates and conditions section, paragraph 4. And I think you will find that this is very consistent, but I think that this is a very important section because this helps detail what the future contract filing will look like. This sets out many of the attributes and components of what that filing will include. I do believe that the two versions are pretty much aligned around these terms. Let's see. Then moving into the additional provisions, I think we're starting to get into the topics that we've already discussed with paragraph 3, paragraph 4, talking about the execution of the hold harmless, and the company's belief that the method that we have proposed provides the most balance, provides the full record for the commission to consider before taking action, instead of having a formula that just applies an adjustment regardless of the facts. So then 6 would be the discussion about the RESRAM that we've already discussed, and I skipped it, but 5 is also the FAC language that we've already discussed. So I think those have all been addressed in some way in my testimony.
And I promised that was my last question, but just a quick follow-up. All of the parties also agree on the 90-day change to cure. Is that correct?
I believe so. I recall as I was looking at the two versions, I think there was but one place that we didn't align around the number 90 as far as our time frame for almost all elements in this tariff.
Yes, and I noticed that just for everyone who will be testifying in the future, that reference to 60 is on the OPC staff MECG Schedule 1, page 3, under the paragraph term.
Correct.
Okay, Mr. Lutz, thank you very much. Hold on just a minute. We are going to go back to re-cross-examination. We will follow the same order of cross-examination, and then that will be followed by redirect. So, Velvet, Ms. Bell, that will start us off for re-cross-examination of Mr. Lutz. Ms. Bell, do you have any questions?
No, Your Honor.
Thank you. And for the record, Ms. Bell said no. She was a little hard to hear there. Mr. Mills for Google, do you have any questions?
Yes, just briefly. Mr. Lutz, turning to the question of the differences between the hold harmless provisions proposed by Velvet and Evergy versus those proposed by OPC staff and MECG, is there explicit recognition in the OPC staff MECG hold harmless provision of the commission's ability to look at what you called intangible benefits?
I do not recall such provision in their version.
Okay. And in the Velvet Evergy version, does the commission have the ability to look at what you've called intangible benefits and reject those as an offset to shortfalls in revenue?
Yes, that is a key attribute of our proposal.
Okay, so under the OPC staff MECG proposal, they can't even look at them. And under your proposal, they can look at them and decide that they don't matter or they shouldn't be considered, or for whatever reason, reject them.
Right. It's my interpretation of the OPC language and the fact that it's similar to the SIL, that there would just be a mechanical calculation done at the time of rate making, where there would be no real opportunity for the consideration of those other factors.
Okay. And in terms of the phrase intangible benefits, would it be fair to call those real benefits that are difficult to quantify?
I think that's fair, yes.
Okay. Now, you were asked some questions by the judge, and I want to sort of go back to the process of what the commission considers when it's doing allocations among customer classes and rate cases. When the PSC makes decisions about those allocations, don't they consider the differences among the classes when they do that?
I believe they
Your
do.
Honor, I don't, I'd like to hear him tie this back to what question of yours this is. I think he is now attempting to redirect on questions that I had. So unless he ties it back to your question, I'm going to object that it's outside the scope of this round of testimony.
Well, it has to, Your Honor, it has to do with the question of how the commission considers costs that should be assigned between different classes of customers. And I think you asked questions of him that leads to what should be assigned, particularly to MKT customers as opposed to other classes.
That was a question from Mr. Woodsmall, not a question from the bench, so I would join with Mr. Woodsmall's objection. I mean, I thought this recross was limited to questions from the bench.
That was my understanding, that recross was limited to questions from the bench. I appreciate the effort, but I was not distinguishing classes of customers. I was distinguishing customers on the schedule MKT versus those not.
Which I think in this instance is analogous to the allocation of cost among different customer classes.
I'll allow it for the time being. Go ahead.
Okay. So in terms of the commission's examination of differences among customer classes, don't they consider things like the fact that residential customers rely on electricity for heat, light, and in fact for health and safety?
I believe so, yes.
And that customers in industrial classes create jobs and have ripple effects throughout the economy?
Yes.
Thank you, Judge. That's all I have.
All right, thank you. Let's move on to Mr. Woodsmall. Did you have any recross examination?
I did, and I'm kind of going to bounce around here because there were a lot of questions. You mentioned about the ability for this customer to opt out of MIA costs. Do you recall those questions from the bench?
I do.
And is it your intention to state here in the context of this tariff that they are opted out of MIA costs or that they may be able to opt out under the normal procedure?
It's the latter. In the tariff, we just highlight that the customer can exercise that option. I don't believe the timing is such that Velvet or any customer has actually exercised that while being part of an MKT plan.
Okay, so just so it's clear, Velvet, whoever, would have MIA cost on their bill until such point as they make the opt-out showing, and then the MIA cost would fall off the following January 1st. Is that correct?
Right. It would all be a matter of how they would synchronize with the statutory timing for that opt-out.
Okay, but until such point, they will be charged MIA cost. Is that correct?
Right. If the timing works out that way. Yes.
Okay. Are you familiar with, oh, you can tell me the formal name of the program, a program by which non-residential customers can purchase RECs from the company?
Yeah, well,
I'm going to object. I believe this is outside the scope of the judge's questions.
I would join in that
Tied
objection.
together. I'm just asking if he's familiar with the program.
if you're referring to Missouri West, I'm not.
Missouri West doesn't have a program by which non-residential customers can purchase RECs.
I'm going to renew my objection and ask for the judge to rule on it, on whether or not, the judge did not ask any questions about RECs or this program.
Your Honor, I'm attempting to lay a foundation to start talking about your RESRAM questions. RECs and RESRAM are all intimately connected.
And I'm going to go ahead and overrule the objection on that point on promise of linking that together shortly. Overruled, go ahead.
You recall the question, sir?
I believe I do. I don't believe that we have a rec sale tariff in the Missouri West jurisdiction.
That's only in the Missouri Metro jurisdiction?
Honestly, I think it's only in our Kansas Central jurisdiction that we have a rec sales tariff currently approved by the commission. Are you by chance referring to like the renewable energy rider?
There you go. Yeah,
Yeah.
that's a mechanism by which non-residential customers can purchase renewable energy and the associated RECs. Is that correct?
Right. In that case, they're not buying RECs per se, but we actually have a resource in the Missouri West jurisdiction. There is a PPA that backs that up, and they are participating in that PPA. They're not. It's not a rec sale contract in the traditional form, where you would go to either a market source or company source to buy, say, Green E RECs or other market certified RECs. This is actual participation in a renewable resource obtained through a purchase power agreement or power purchase agreement.
And would you agree that in that instance, those customers are bringing their own renewables in the form of RECs to the table?
Yes, I would.
Okay, and are those customers, do you exempt them from the RESRAM charge in those instances?
We have not.
So in the same situation, you would propose to exempt Velvet, but not these other customers that participate in the renewable energy program that you discussed?
Well, I'm trying to think of the way to address that, because I believe that there's a level of nuance here that's I believe being lost, and especially in the Missouri West, deployment of the renewable energy rider. It's largely configured as a monetary hedge, meaning that the participation in their green renewables is converted to an adjustment. It's difficult to draw distinctions between the two, or draw the right comparison between the two because of the structures.
Okay, but.
I mean, I
let me ask-
hesitate to agree with you completely.
Okay, let me ask it this way then. Through this renewable energy program that you described,
Mhm.
Customers may be purchasing energy and RECs that equals 15% of their load. Is that correct?
They could be, yes.
Okay, and even though they are meeting the res requirement in Missouri, they are still charged a RESRAM cost. Is that correct?
That is correct.
Okay, we'll move on. You mentioned somewhere, when discussing the EDR, and I wrote down the quote that you attempted to quote, meet in the middle, end quote. Do you recall that statement?
I do.
I was just looking through the tariff attached to your stipulation from last night. Can you tell me where that quote meets in the middle?
Right. You'll have to forgive me. I believe I misspoke. I think what you caught me on is, and if you remember, I've been working feverishly through the
I'm
settlement
not
work,
holding it
and I
understand.
right. I've brought into the discussion items from that were not in our unanimous stipulation, non-unanimous stipulation. You are
Okay.
correct.
And I'm not pointing fingers, but what you were referring to was things we talked about in settlement talks, right? It's not in any formal document now, is that correct?
That is. Thank you for pointing that out.
Yeah, no harm, no foul. So, and just so the record's clear, there has been, in the context of the tariff that was attached to your non-unanimous stipulation from last night, there is no movement on that EDR issue, is that correct?
There is no alternative position, correct, to what the OPC has offered. Yes.
Okay. There was some discussion about the hold harmless. I'm sorry, I was giggling at someone. There was some discussion in response to a question from the bench about the hold harmless language. Do you recall that?
I do.
Let me ask you a hypothetical. Well, before we start the hypothetical, would you agree that in your proposed tariff, where it talks about capacity costs, rates for capacity service, are you familiar with that?
I am.
Would you agree that that provides for the opportunity for the company to meet capacity needs of an MKT customer, possibly through a PPA or by building to meet that capacity need? Is that correct?
Correct.
Okay, now the hypothetical. Let's say you have a 100 megawatt MKT customer, so you need 100 megawatts of capacity, right?
Okay.
You execute a PPA for 100 megawatts of capacity, and the customer goes away, closes down, what have you. What happens with the cost for that PPA?
Well, I would say that some of that will be dependent on the language that is memorialized in the final contract with the customer under the market rate.
Let me ask it this way then. Is it the company's intention to hold non-MKT customers harmless from such a PPA?
I'm pausing because I'm trying to weigh the idea that there could be an upside from that capacity for non-participating customers if made available. So I guess what I would say is that we would want to look at the full impact of that to determine whether it was to the non-participating customers' benefit to get that access to that capacity. But Conceptually, I would say yes. It would be our intention to not impact non-participating customers negatively because of capacity obtained for customers under MKT.
Okay, and similarly, if you decided not through a PPA, but by building combustion turbines to get up to 100 megawatts of capacity, and this customer goes away, would you want to hold customers, non-MKT customers, harmless from any detriments associated with that capacity that you built?
Again, I'll say conceptually, yes, but the details would be worked out with the respective customer in the execution of that at the time of the market rate contract.
Okay. Now, you're familiar with the EDR statute provision in general, is that correct?
I am.
Would you agree that to the extent the company has a customer join its system and receives discounts, the company benefits because all the other customers are paying for that discount?
Well, I struggle with the characterization because I think that it discounts the genesis of the EDR in the first place. You know, that the legislature has reviewed and approved that mechanism and put it in play under a specific design, and the company and the commission through its rulemaking and the company through its tariffs and exercising that complies with those. So I hesitate to agree because there's a intent that I think is behind or foundational to the EDR that we're completely complying with. You know, whether the company may not be harmed by it, but I don't know that I see it as being a profit source or something that's somehow evil or unanticipated by the legislature in their execution of that provision.
I'm not disputing anything that you said. I'm trying to just ask a simple question. Let's go at it this way. Your rates currently have some profit built into them, return on equity, is that correct?
Right, yes.
And some amount of that is captured through energy charges, is that correct?
Yes.
So to the extent ABC company moves into your service area and uses electricity, the company is going to make more money because there are some amount of ROE in the energy charges, is that correct?
I don't know.
Well, we could go back through this. Can you tell me where you're having problems with it? It seems pretty simple.
Well, it is, but I mean, I think what you're doing in a way is taking advantage of the exercise of rate making and the generalization of costs and allocations and such, and characterizing a very specific EDR step and trying to turn it into, you know, some kind of a hidden subsidy. And I don't think it's hidden at all. I don't think that there's any effort to try to game systems and bury charges in the energy component, or I guess is where I'm struggling.
You're trying to read way too much into the question, and I get it. When I was in 5th grade and I'd read a true-false question, I'd do the same thing. But you said that there is return on equity, some amount of return on equity that is captured in energy charges currently. Is that correct?
Right. I'll just say it this way, that in the overall rate making scenario, there is the recovery of expenses there's the recovery and return on plant, and all of that is accumulated into a revenue requirement that's captured and recovered through the company's rate designs through energy charges, demand charges, and customer charges. How about
Right.
that? I could say that.
Okay. And to take that one step further, there is some recovery of ROE in energy charges. Is that correct?
Say that again. I'm struggling to follow your question. Could you ask that one more time, please?
There is some recovery, not complete recovery. I'm just saying there is some recovery of return in the company's energy charges. Is that correct?
Yes.
Okay, so given that there's some recovery return in energy charges, the company is better off with increased sales. Is that correct?
Well, yeah, everyone benefits from increased sales.
Not disputing that. The company is better off with increased sales. Is that correct?
Right. Current rate making mechanisms, everyone benefits from increased sales. Yes.
So to the extent that a new customer comes into your service area and uses electricity, the company will benefit through an increased return on equity compared to all else being equal.
Okay. Yes, I'll accept that.
Okay. Then let's take that one step further. Let's say a customer comes to your service area and uses increased electricity with an EDR discount. The company will benefit because there's increased sales. Is that correct?
Certainly, because that part of the equation hasn't changed in your scenario.
Correct. The discount is borne entirely by other customers. True?
Well, but it's intentional. I mean, I guess I want to come back to
I'm not denying that. I'm just saying the discount is borne by all the other customers.
right. The way the EDR is structured, that cost, yes, is socialized as a shared benefit or a shared expense of bringing that customer into the area through the EDR provisions. Yes.
Okay. No further questions. Thank you.
Thank you. That takes us to staff. Any cross-examination, Mr. Keeble?
Very, very briefly, Judge. Mr. Lutz, on the tariff that was attached to the Evergy Velvet stipulation, excuse me, the RESRAM provision, I believe, is paragraph 6 under additional provisions. Is that correct, sir?
It is correct.
And if I'm reading this correctly, the last sentence there says that renewable attributes means renewable energy credits that the MKT customer has retired or had retired on its behalf. Did I read that correctly?
You did. Yes.
Now, in the renewable energy statute, the provisions for retiring renewable energy credits and how many need to be retired and all that good stuff, the statute is directed toward the utility companies retiring of credits, is it not?
Correct.
Okay. And I don't believe the statute makes any provision for the utility getting credit for RECs that the customer retires. Is that your understanding as well?
Correct. Yes.
Okay. I think it's, oh, yeah. No, that's all I have, Jeff. Thanks.
Thank you. And that takes us to Mr. Kleiser, Office of the Public Counsel.
Thank you.
I want to say, Your Honor, I didn't have a whole lot of questions, but boy, you asked some really good ones. So I apologize in advance. This might take up a little while. I'll try and make it quick. Good afternoon again, Mr. Lutz.
Good afternoon.
All right, let's start with the recs and the revenue, the RESRAM. I mean, you were asked a series of questions from the bench regarding, you know, how you interpreted what Lena Mantle has suggested with regard to the RESRAM and how the company's RESRAM mechanism would work. Do you recall all that?
I do.
All right. I want to walk through the company's mechanism just so I have a good understanding of how it works and so I can brief it easily. And to do that, I'm going to ask you to go down a little hypothetical with me. You okay with that?
I am.
All right. I'm going to have you be Evergy. I'm going to be a customer who takes under this tariff. All right?
Yep. Okay.
And for the sake of this, I'm going to say I use 100 megawatts, which I'm going to ask you really quick. 100 megawatts is the same as 100,000 kilowatts, correct?
Yes.
All right. So you're Evergy. I'm a customer who's taking under the MKT tariff, and I take 100 megawatts. You follow me so far?
I am.
And for the purpose of this, there's no one else right now. Okay. If I'm buying 100 megawatts of energy from Evergy, Evergy has sales of 100 megawatts for just right now. You would agree with that?
Yes, I do.
All right. And if there's a RES statute out there, a Renewable Energy Standard statute that says Evergy has to, 15% of Evergy's sales have to come from renewables, you would assume, or you would agree with me that 15% of that 100 megawatts needs to be renewable, because Evergy sold to me. Do you agree with me?
Or, well, to follow the statute, or there would be a retirement of RECs equal to that.
Right.
Yeah.
And again, we're gonna walk through this real slow. I just want to make sure it's all clear. So,
Okay.
if Evergy is selling me 100 megawatts and this RED statute is in place, then either Evergy has to, 15% of that 100 megawatts has to come from renewables, or you have 15% worth of renewable RECs retired. Is that accurate?
Yes.
And we're just going to refer to that as 15 megawatts, right? 15% of 100, 15?
Yes.
Okay, great. So let's add into this that I, the company, purchased, the customer, sorry, thank you. I am going to purchase 100 megawatts of renewable energy credits myself, and I'm going to retire them. Now, since I've purchased 100 megawatts of renewable energy credits and retired them, I can say all of my energy was renewable, correct?
Correct.
But the fact that I've purchased 100 megawatts does not mean that Evergy sold me 100 megawatts of renewable energy. In other words, my decision to retire 100 megawatts doesn't translate into Evergy retiring 100 megawatts, correct? Worth of RECs, sorry.
Now, I need to stop you there because retiring 100, now you're switching into compliance now. Is that what you, the execution of compliance under the RES standard? Is that what you're referring to?
Well, I want to make sure that things are really clear here. So if I retire 100 megawatts of renewable energy credits as a customer, what can Evergy claim with regard to that?
We would have no claim on customer retirements for the purpose of RES compliance.
Okay, so again, and I promise you, I'm going to get to how yours operates. I'm going to give you your chance to explain it. I'm just going real slow.
Okay.
For right now, you, Evergy, are still on the hook for meeting that 15 megawatts of renewable energy imposed by the RES, correct?
Right. Absent anything that's on the table before the commission today.
Right, okay, let's get to that part. So this is the critical part. If I understand Evergy's proposal, the 100 megawatts of renewable energy that I have retired, you're going to subtract that from the amount of retail sales that Evergy has provided to me for the purposes of the Renewable Energy Standard statute. Is that fair and accurate?
That is correct.
Okay, so for the purpose of the RES, we're going to say Since I retired 100 megawatts, it's as if Evergy didn't sell me anything.
For the purpose of compliance, yes.
Right, perfect. I wanted to make sure that how this operates was really clear. Okay, now, I am assuming that you're aware there's this legal issue out there, and I'm not
Yes.
about to ask you any legal questions.
Thank you.
I do have a series of questions that goes on from this. I want to ask you, let's assume that there's a third party who comes in somewhere down the line. We're going to call them Regrow Missouri. And they bring a legal challenge to this tariff, and they say, you can't do that, Evergy, and a court agrees with them. So we're back to the situation where Evergy is on the hook for 15 megawatts. Can we just assume that occurs for just a second?
Okay.
You okay with that?
For the
Under that
illustration, sure.
Under that scenario, between you and me, who should pay for that 15 megawatts of renewable energy?
And you being the MKT customer and me being the company?
Yes.
Well, I would say it's probably not clear. I think that the two of us would have to talk about it.
Let's add in another party. Let's add in all the other customers. Is the answer going to be all the other customers, or is it still going to be someone between Evergy and the MKT customer?
Well, certainly the role or the goal is to not have other customers cover that cost. But I think that the way to achieve it is where you're trying to lead, and that is to create a structure where that cost is dealt with in a different way. So I mean, I think we have to start to jump towards the conclusion a bit to get to the answer.
That's fair. Honestly, I wasn't trying to lead anywhere. I really wanted to know, what happens if this goes wrong, who's going to pay for it. But
Well,
I'm actually, okay.
Well, Mr. Kleiser, I guess what I was just going to say is that, as we get further down the stream, there's higher amounts of speculation for the details. Like what is the nature of the lawsuit? What aspect of it? Was it an issue with simply the calculation? Was there, what was the nature of the ruling? There are a lot of key facts, if you will, that I think start to inform the final answer on what we would do or what the customer would do. But I can talk from just a spirit perspective, which is probably more relevant to where we're at today, is that we are trying to not create a situation where there's cost being created unreasonably or unnecessarily, and that additional recoveries are being made when in this case the renewables have already been procured, retired, and used, for the purpose of what the RES is trying to accomplish. So I hesitate on some of these because the devil's in the details.
Well said. I'm actually going to move on from that issue, so thank you. That was very helpful. All right. Now, you were asked a question from the bench whether or not it was your intent that MKT customers would be entirely responsible for the cost that they caused to be incurred. I butchered that ending, but do you recall what I'm referring to?
I do.
And you agreed, right? It is Evergy's intention that MKT customers are going to be responsible for their own costs, correct?
Correct.
I mean, it is accurate to say that Evergy is not seeking to have non-MKT customers subsidizing the MKT customers, right?
Right. Not by design. I mean, that's not the intent. No.
And you'd agree with me that if everything goes according to plan and the MKT customers are able to cover their own costs, there is no need for a hold harmless provision in that regard, right?
Correct. That in my conversations, I think with Mr. Woodsmall, that was the you need an event. You need that triggering event for those issues to come into play. So yeah, I agree.
Right. The hold harmless agreement only matters if, for whatever reason, MKT customers don't cover all of their own costs,
Correct.
right?
Correct.
Right. And there was a lot of discussion of Nucor in kind of regards to that. Do you remember that?
I do.
And just to be clear, when it came to the SIL tariff, the company was willing to forego the kind of intangible benefits analysis that you want in this tariff, correct?
Correct. You know, the situation was quite a bit different with Nucor. Yes. You know, plus I pointed out that that was achieved as part of a settlement. So there was a broad set of gives and takes that occurred through that agreement, and this was part of that.
And just so I have it in the record, Nucor did take service under an SIL contract, right?
Correct.
And you would agree with me that Nucor did produce benefits?
I believe so. I believe that they've performed largely as expected. Yeah.
Thank you. All right, just a couple more things, really quick. You had talked about how it was the intent, well, you had gotten a question from the bench regarding riders. Do you recall that?
I did.
And yours said that the intent was to exclude MKT customers from all riders currently in effect. Do you recall that?
I do.
All right. What about riders that are not currently in effect, i.e. that might come into effect in the future?
Right. My experience with that, I mean, a few of these riders have come into being since I've been here. And so I think the process that we usually follow is we review the proceeding that brings that into play, and then we would execute tariff revisions where appropriate to deploy that consistent with the outcome of the filing that brought the rider into being.
If there was a statute that imposed a rider and did not give discretion, it effectively said all customers must be subject to this rider, you would agree with me that in the case of this MKT tariff, it would need to be adjusted to reflect that rider, correct?
Well, I would just say that it would be part of that consideration. I don't want to constrain the future, I guess, based on my response today. But I would say that if we had a mandated cost recovery item, we would consider that and look for the appropriate way to include it on all of the applicable tariffs that the company has. Yes.
I'm sorry, I just remembered a question I had regarding Nucor. Can you tell me, was Nucor initially served off the SIL, or did they first get served under a tariff with an EDR discount?
No, I believe that they were in a different place as far as construction relative to the rate making and the filings that we did. I believe they were already constructing, so they had power for construction purposes in advance of the filing. So I believe they went straight on the SIL rate.
So
sorry.
I'm sorry, just to make sure it's very clear, Nucor did not take an EDR discount.
I don't believe so. I don't believe so. I mean, and what I was just going to finish up was, you know, this situation, we've got a much longer glide path, if you will, from when a need was established to when it'll be executed. You know, the decision-making processes and many of the things that are occurring in this context are kind of on a different timeline and different positioned differently relative to the company than Nucor was.
Thanks. All right, last line of questioning. It should be fairly simple. You were asked a series of questions from the bench regarding, you know, what would you add or subtract from this tariff or that tariff? I want to go through some of the differences real quick that I don't think were mentioned, just to knock them out of the way.
Okay.
So do you have a copy of the demonstrative from the OPC that was sent out?
I do. I've got it.
All right, starting under the first bullet point for availability, at the end, there's a line that says, provided the new customer's current load reaches a monthly demand minimum of 50,000 kilowatts.
Yes.
Would you find that objectionable?
I would not.
If you'll flip over 2 pages under availability continued, starting with a paragraph that reads service under this tariff. At the very end, there was a line that was struck that reads, unless otherwise ordered by the commission when approving a contract for service under this tariff. Would you object to the striking that line?
I would not.
Flipping over 2 more pages, under availability continued again, to the paragraph starting availability of service under this tariff. At the end of the paragraph, there's a line that's been added. It says availability is subject to commission review. Would you object to adding that line?
Let's see. I just want to make sure I noticed a strike above it as well. So just looking at the entire context.
I do apologize, but that was
Yep.
not intentional. I'm trying to move quickly.
Yeah, yeah,
Would
no,
you be
no-
okay ranking or the commission and adding availability subject to commission review, both of those together?
Right. No, I would not object to either of those changes.
Super. And then flipping over another page, and way down at the bottom, under additional provisions, there's an addition that reads, identified in the company rules and regulations, period, as applicable, SPP settlements will be applied at the time service to the, and then continue on the next page, active billing period.
Right.
Would you
I would
object
not.
to the addition?
I would not object to that one.
Super. That was all of my questions. Thank you very much.
Okay.
Thank you, and that brings us to redirect from Avergy. Any questions on redirect?
Yes, Judge, I have a number. He's covered quite the waterfront. Before I begin, I'd like to ask whether my witness or my court reporter needs a break at all. He's been on the stand for almost 2 hours.
Very thoughtful. I was coming to the same question. I was going to go after Mr. Lutz, but if anyone needs a break now, sounds like a good time.
I would prefer after, if possible.
Let's go ahead and go through, and we'll see how far we get. Go ahead.
All right, thank you, Judge. Mr. Lutz, they covered a lot of the waterfront with you. I think I'd like to structure my redirect by going to the judge's questions and covering some of the issues that way.
Okay.
Particularly, I believe he asked you a question about what provisions do you oppose? And the first one that you mentioned was the provision the Public Counsel and MECG and staff have regarding the requirement that the customer not be using an EDR for 5 years. Do you recall that?
I do.
Is it your understanding that the EDR is a creature of statute?
It is. I do. Yes.
Does the company have discretion to deny a customer that is eligible under the statute from using that EDR?
Your
Only
Honor, I
within.
object. It's a legal question.
As you understand the practice.
It's also misrepresenting the tariff. The tariff does not purport to prevent someone from using the EDR. The tariff purports to prevent someone from using the MKT tariff who has used the EDR. So Mr. Fisher is misrepresenting the tariff language.
Mr. Fisher?
Judge, Mr. Keeble may be right. I may have made a mistake on how I stated that. My intention was that my intention was to ask the question whether the company had discretion in denying a customer that wanted to use the EDR under the statute. If they were eligible under the statute, couldn't the company deny that, then that
No
opportunity?
legal question.
I'm going to overrule and allow the answer. Go ahead, Mr. Fisher.
Okay. I believe that our only ability to deny is within those applicability terms. As long as they are in compliance with those, we would issue the EDR.
Okay. And without the ability to have an EDR, do you believe that it would be more difficult or less difficult to attract customers to the Kansas City area region?
Objection calls for speculation. Do you believe?
Mr. Fisher, do you have a response?
Well, again, Mr. Lutz has been doing this for 18 years, it sounds like, and I can rephrase it to say if you'd like, but I think he can answer the question.
No, I'm going to go ahead and overrule. Please go ahead and answer the question.
Yes, Mr. Fisher, I've worked on a few of these large customer related things, and yes, that price sensitivity is a significant issue, and I think that the lack of an EDR would be problematic.
In the case of Velvet, which we're talking about in this case, is the EDR being used as any kind of transition to the new tariff?
I believe it is. Yes.
And would you explain why that's necessary? Is your understanding?
Right. Under my understanding, and as we've exhibited in our testimony and both written and oral, is that there is a ramp up period associated with these customers that, unlike many where they could, flip a switch and be at full load, this will take a period of time, potentially 5 years, for us to get to that steady state load. And so allowing the EDR and the large power rate to be that introductory rate schedule, it allows for that ramping. It allows us to keep the higher thresholds that we desire for these special rates, and allow the customer to kind of grow into it, as opposed to some other approach. So certainly the EDR and the large power rate in this class give us that transition that works well for not only us but for the customer.
And is your tariff, your MKT tariff, designed just for Velvet or for others?
Oh, certainly for others. I mean, the design case element can't be ignored, but we've certainly had conversations with other customers where we've been able to test and make sure that what we're doing makes sense for a broader source of potential customers than just Velvet.
Okay. Going on to the second major area that you had concerns with, I think it was in the hold harmless area in paragraph 4.
Yes.
Do you recall those questions?
I do.
I believe in those discussions you talked about, you believe the commission should consider intangible factors. Is that right?
Yes.
Is another way of saying that they should consider externalities and other benefits?
Yes.
In your 18 years around rate making here at the Missouri Public Service Commission, have you heard parties suggest or perhaps read orders from the commission that suggested that the commission should consider all relevant factors in general rate cases?
Yes. I mean, that's almost the perfect phrasing, I think, for what our goal is just to make sure that the full breadth of factors are being considered before acting. Our concern is with this prescriptive language that drives to a conclusion without any opportunity to analyze and understand what's going on.
So is it my understanding you believe the commission should take into account all sides of the issue?
Yes.
And have you read orders that the commission, for example, the recent the transportation electrification order, where they took into account other things besides just the rate making aspects? They would have taken into account efficiency and off-peak usage and that kind of thing.
Certainly, I think that's a good recent example.
And in a MIA case, would they take it more into account, including social benefits and public policy factors in developing their MIA rates?
Yes.
You were also asked questions about whether you'd ever heard of industrial customers having such things taken into account. Are you familiar with a case involving Noranda a few years ago?
From a distance, but yes, I am familiar.
Do you know if the commission took into account the employment situation of Southeast Missouri in resolving that case?
I believe they did, yes.
And is it your understanding that in the Nucor case, the commission took a look at economic development benefits and employment benefits and tax revenues and those kinds of things were part of that record?
Yes,
All of those things would be considered part of all relevant factors. Is that your impression?
agreed. And I think that's definitely in the spirit of what we're seeking in the proposal that we have.
So that's what the company's asking for, that the commission consider all relevant factors when it's looking at whether the costs or whether the revenues are exceeding the costs and whether there should be an adjustment?
Correct.
The third area that you suggested that you were concerned about was the ResRAM charge.
Yes.
Well, I think you've covered that quite adequately. You were asked about the substation voltage, I believe, and is it your understanding that the company, that Evergy's proposed tariff has deleted any discretion in increasing the voltage levels?
Correct.
Was that taken out because the staff and public counsel raised that concern?
It was certainly, we were seeking to find as many opportunities to come together as we could.
I believe you were also asked whether you had any other concerns. Did you discuss at all the concern about the securitization provision in the public counsel's tariff?
Yes, there was some questions about that. Yes.
What's the company's view about whether that should be included in the tariff that the commission might approve?
Right.
Your Honor, is he asking a legal question about whether a securitization charge can be exempted, or is he just, asking him to talk about securitization? Because there's a statute that says all customers have to pick up securitization costs.
That's
That's
Judge,
not
I
the
was
question I
asking,
heard.
I'm sorry, go ahead.
No, is that an objection?
Yeah. My objection was, is he asking him to give a legal conclusion about whether securitization costs can be exempted for a particular customer?
That's not even the question I heard.
Okay.
Okay, so overruled if that is an objection.
Would you have him repeat the question then?
I think we're getting right there.
Let me just
Mr. Fisher?
rephrase it. Let me
Yes, please.
rephrase it, Mr. Lutz. What is the company's view about whether the provision in the public counsel's tariff related to the securitization should be included?
I think it should not. I think it's premature, and I think our proposal has left that for the securitization filing and the process that I described to deal with it in that context.
Has the commission granted Evergy a securitization surcharge?
No.
In the case of Nucor, the public counsel has suggested that there is just a straight hold harmless clause, I think is how they've referred to it, or something like that. In the event the commission looked at the Nucor costs and revenues in some future rate case, would you expect them to consider all relevant factors in that decision?
Yes.
Okay. Judge, with that, that's all the questions I have.
Thank you. We are going to go on recess until 3:15. Everyone, please go stretch your legs. 3:15. We're at recess and off the record.
Do you have any guidance on how long you intend to
All right, the hour of recess having expired, let's go back on the record. We are in the afternoon stages of our hearing for Evergy, Missouri West request for a special high load tariff. That is file number EO-2022-0061. We're about to take up the testimony of Mr. Darren R. Ives of Evergy. Mr. Ives, if you would please speak up on WebEx, I will swear you in.
Judge, this is Darren Ives. Can you hear me?
Yes, sir. Thank you. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you. And Mr. Fisher, your witness.
Thank you, sir. Mr. Ives, would you state your name and address for the record?
Yes, my name is Darren Ives. My address is 1200 Main, Kansas City, Missouri.
Are you the same Darren Ives that caused to be filed in this case confidential and public versions of your direct testimony, which have been marked as Exhibit 1 and 2 respectively, and surrebuttal testimony, which has been marked as Exhibit 3?
I am.
Do you have any changes or corrections that you need to make to any of those testimonies?
None that I'm aware of.
If I were to ask you the questions contained in those testimonies, would your answers be the same, and are they true and accurate to the best of your knowledge and belief?
Yes.
Judge, with that, I would move for the admission of Exhibits 1, 2, and 3 and tender Mr. Ives for cross-examination.
Thank you, sir. Are there any objections to the admission of exhibit numbers 1, 2, or 3 onto the hearing record?
This is not an objection, Judge, but just a question. 1 and 2, which one is?
One, that is interesting. One is the confidential version and 2 is the public. Is that correct, Mr. Fisher?
Yes, that's how it was marked.
Okay, so 1 is confidential, 2 is public. Okay.
Yes.
Okay. Yes, go ahead. Nope, thought I heard somebody. Without objection, then exhibits 1, 2, and 3 are admitted onto the hearing record. Mr. Fisher has tendered the witness. According to my list, that means cross-examination by Velvet.
Thank you, Your Honor. Good afternoon, Mr. Ives. Making sure you can hear me okay.
I hear you just fine. Good afternoon.
Great, thank you. First question, if the commission accepts the OPC proposed tariff as attached to the OPC stipulation as Schedule 1, would Evergy offer a contract to Velvet?
No, I don't believe Evergy can offer under the conditions that are in the OPC staff and MECG tariff, and I also believe it's unlikely a prospective customer can accept under that tariff.
There has been a lot of discussion about a deficiency in a rate case where the revenues do not exceed the cost. What happens if revenues exceed the expenses?
Yeah, if revenues exceed the expenses in a case, and I'll just give you a good example, if everything worked exactly as intended in pricing out the contract, the current proposal by design case customer Velvet has the renewable charge, and under our tariff proposal, that would be a benefit to all customers, all non-MKT customers, and those revenues in excess of costs would flow back in that case to the benefit of all those non-MKT customers.
Okay, so let's look at the energy rate. So the first piece being energy price at SPP day-ahead prices, how would you expect that price to compare with revenues?
Yeah, so energy is designed in our tariff proposal to be a direct pass-through of the costs that we're incurring to supply energy at that SPP node for Velvet. So it should energy should be a straight pass-through. Revenue should equal cost.
Okay, and would you agree that the customer service charge as proposed in the customer service charges proposed for MKT customers is higher than the customer service charge proposed in the SIL tariff?
Yes. And I think, to be fair, designed under some of the same construct and thoughts as how we came up with that SIL, but recognizing differences in service to design customer Velvet as opposed to neutral to the SIL.
And you recently filed a rate case in which you made a comment about whether or not the estimates in the new core contract for cost exceed the revenues as expected. Is that correct?
In terms of whether the revenues exceed the cost as expected?
Uh-huh.
Yes.
There's been a lot of discussion about the addition to the OPC stipulation regarding the Schedule PED. Do you recall that?
I do.
Okay, and the stipulation proposed by Evergy and Velvet is silent on that issue?
It is.
There's no prohibition.
No prohibition to utilization of PED in advance of going on to the market tariff. There is a prohibition of stacking the PED with the market tariff.
And the OPC stipulation, in your understanding, is a complete prohibition of the use of PED for MKT customers?
For 5 years.
Ms. Bell, could you repeat that question, please? And perhaps maybe move your microphone just a tad bit closer to your mouth?
Sure. So the OPC stipulation is proposing a complete prohibition on the use of PED for MKT customers?
Well, to be technical, it says that anybody that's going on to the MKT tariff will not have accepted a discount under the PED in the past 5 years.
Okay, and how long currently is the PED discount available?
Well, so the PED provides a 5-year discount, and the legislation that provides for it has a sunset. I don't have it in front of me. I think it probably sunsets in the latter part of the 2020s, like 2028.
Okay, do you have, so between the two positions, do you have any thoughts on how to resolve the conflict between the two stipulations?
Yeah, I have a couple. I mean, I'll start with the foundation and why we're in the position we're in the draft that we submitted. You know, and I think, without belaboring the point, I think the PED is statutorily provided for, and I think there is generally no prohibition today from a customer moving on to a special contract tariff or an SIL tariff or any other tariff from the PED. So that's why we're at where we're at. All that said, Mr. Lutz alluded to in his discussion some thoughts that were discussed with parties during our discussions to try and work this out. certainly we made a lot of progress on a lot of fronts, as you can tell by the similarity of the tariffs during those discussions. One of the things that
Settlement discussions being privileged per commission rules.
Let's hold on just a minute. Councils, we have an objection. I want to make sure that I get that. Mr. Keeble, go ahead.
Yeah, the commission rules are fairly clear that settlement discussions are privileged communications. And it sounds to me like Mr. Ives is about to delve into settlement discussions that did not make it into either of the filed stipulations with tariffs attached. So I think it's objectionable as being privileged settlement discussion.
I joined in that. I gave a pass when Mr. Ives did it now, or when Mr. Lutz did it. Now it seems like Mr. Ives is doubling down on it. So, yeah, I would object.
I am not going to rule on the objections right now, because I did also let that pass when it was first mentioned. It was uncomfortable, but it didn't seem to cross a line. I'm going to ask Ms. Bell if you could perhaps rephrase or get at your issue perhaps a different way.
Yes, Your Honor. I think my question is not whether about any sort of settlement discussions. My question is, does Mr. Ives have any independent thoughts of his own on how to resolve the conflict between the two positions of the parties?
Okay, I'm going to let that go. Go ahead, Mr. Ives.
Thank you. And not intentional to move into settlement discussions. I was actually just trying to restate what was in the front page of OPC and party stipulation that indicated parties had met repeatedly through the pendency of the case in an effort to reach settlement. So I was trying to restate that point. But regardless, when we saw at 5 o'clock last night that the first indication of anything in the record in this docket around the Schedule PED, which was the item inserted into OPC, MECG, and staff's proposed tariff, we certainly had some discussions over the evening contemplating that and feel comfortable that there is a solution which has already been discussed in testimony in some respects from the standpoint that design case customer Velvet has already indicated that they don't intend to use the economic development rider through the entire period that would be available to them. They've indicated in their letter of support, I believe, that they would intend to move to this market tariff in 2025, which would be somewhere shy for sure of the 5 years they'd be eligible to participate in that. We could memorialize that thought process to, as Mr. Lutz indicated, find a way to meet in the middle from where these two stipulations are in front of the commission today, that said if you could either be on PED for 2 years or up to an average monthly peak of 50 megawatts, recognizing where we've been all along, that the ramp is an important characteristic to this set of customers, and it would be very difficult for the company and for a customer coming in with that ramp to manage the renewable supply that the customer intends to do, match to the energy that we'll be charging under this tariff during the ramp cycle. So that would be a solution that could be advanced.
Okay, do you know, just one moment. Mr. Ives, do you know, do you recall when Evergy approved Velvet for the PED?
I don't remember the exact date. It may be in testimony, but it was, I want to say it was in the fall of last year.
And do you know if it was before or after the market agreements were executed?
Absolutely, it was before. You know, I've got testimony in talking about the process that's we've undergone in not only with design case customer Velvet, but with some other interested parties over the last number of years. And we did not come to an acceptable resolution that worked for Evergy and Velvet in regards to schedule MKT until shortly before we made our first outreach to parties to discuss it in September, mid-September of this last year.
Okay, and you have reviewed the two competing stipulations?
I have a few different ways, yes.
And can you highlight the areas of differences where Evergy would object to OPC's differences generally?
Yeah, generally I'll answer that question. In order to be fairly similar to the testimony provided by Mr. Lutz, I think. But certainly the item we were just discussing about the application of Schedule PED is a difference that we wouldn't accept as written, but I mentioned there might be an ability to find a compromise there as I laid out. The RESRAM, which Mr. Lutz discussed in quite a bit of detail, but the position advanced by OPC, MECG, and staff, that does not appear to be workable, and in my opinion will create the impact of additional compliance cost beyond what is required and should be required to meet the RES compliance standards. So I would continue to advocate for our position, which calls for a variance from the rule in terms of calculating that compliance. The hold harmless, Mr. Lutz talked about for a fair amount of time. I think it got summarized well with his discussions with the judge and on redirect with Mr. Fisher. But really what we're asking for is the ability for the commission to consider all relevant factors. The analogy I would make there is that maybe in a discussion Mr. Lutz had with Mr. Woodsmall, there was a question about if new suppliers came in related to a customer, who gets the benefit of that? In a normal circumstance, that ultimately accrues to the benefit of all customers, including the large customer that is being supplied. The position that MECG, OPC, and staff promote would provide that benefit of those suppliers coming in to all non-MKT customers, but would not give any value to that to the MKT customer that brought that supplier forward. that's why we think the commission should be able to consider all relevant factors before making that determination. Lastly, Ms. Bell, Mr. Lutz talked about the substation voltage. We believe it's appropriate to leave the substation voltage in there. We believe that there could be a class of customer that would qualify for this, that might not be interested in owning that substation, would prefer us to own that. And ultimately, the cost that would be built into the market contract would recover those costs. So we don't think there's any reason not to include that in our tariff. And then the securitization line that was added in that stipulation by the parties, I wholeheartedly agree with Mr. Lutz. It is premature to put that line item in one tariff. The commission will ultimately have to make a determination on a financing application and give a financing order that will address the applicability of securitized charges to all customers. And that's the time to make that appropriate assessment. Hang on one second, just let me look. Other than that, there are some minor word changes that Mr. Kaiser went through with Mr. Lutz, that I generally agree with Mr. Lutz answers on those. Under the term section of the tariff, there is one date for written notice that I think is listed at 60 days in the party stipulation and listed in 90 days in the stipulation advanced by Evergy and Velvet. I would suggest moving that to the 90 days, consistent with the other date references in the tariff that we both have. I think those are the points that I would highlight.
Okay, thank you. I think it was Mr. Keeble who had asked Mr. Lutz some questions about employment numbers and about whether or not there's any commitment by a customer to stay on the Evergy system. Do you believe it's a reasonable expectation that a customer, after investing $800 million, would leave Evergy's system?
I've been in discussion with either Velvet or other potential customers of similar scale for a few years now. I think they are doing an incredible amount of due diligence and working with a number of parties throughout the state and the region and locally to ensure that when they do make a final decision to come in, that they can be a long-term customer and community partner.
Thank you. No further questions, Your Honor.
Thank you, Ms. Bell. That takes us to Google. Mr. Mills, any cross-examination?
Just briefly, Mr. Ives, you discussed the possibility of some sort of a limitation on customers using the PED before moving to MKT. You recall that?
I do.
Have you discussed that sort of limitation with any other prospective customers other than Velvet?
I have not. I have not discussed it directly with other customers in terms of having direct feedback from them of whether or not it would work for them.
So it is possible that in offering something like that to make this tariff work for Velvet, it's possible that it may foreclose it as an avenue for future customers. Is that correct?
It is certainly possible, Mr. Mills. I wholeheartedly believe that after working on these types of customers for a number of years, that it takes all the resources of the state to be successful in this economic development. Ms. McCarthy talks about that a fair amount in her testimony. I know for a fact that in discussions when we only had economic development rates or PED, that was not enough to entice this customer set to come into Missouri. So I know it takes both. To your point, I don't know if it takes full availability of both or if the position that I just discussed would be acceptable. I have not talked with all those customers.
Thank you, Judge. That's all the questions I have.
Thank you, and that takes us to Mr. Woodsmall.
Yes, just very briefly. Mr. Ives, you recall some questioning from Ms. Bell trying to minimize the concern that Velvet or one of these customers may leave, and you said that you believe they intend to be, quote, long-term customer and community partners.
I remember the discussion. I might not agree with all the words of your question.
You recall saying that based upon your discussions, that you believe that they intended to be long-term customers and community partners?
Yes, I do.
Do you believe that despite such intentions that companies do go out of business like Enron?
They do. Could happen to a customer on PED or not, or on Schedule MKT or not.
Yeah, so there is no assurances that if the company builds capacity or enters into a capacity PPA to serve this MKT customer, that the MKT customer will be there through the end of that PPA. Is that true?
There's no assurances that that customer will be there till the end of that term, for sure. No assurances, Mr. Woodsmall, that I'll be here at the end of that term. But
thank you, sir. No further questions.
Okay. We will have redirect, so your counsel, Mr. Ives, will be able to see if you want to flesh that out any further. That'll take us to cross-examination from Mr. Keeble.
Yeah, very briefly, Mr. Ives, Schedule DRI-2 attached to your direct testimony is the exemplar market rate contract, correct?
It's been since last night when I looked at that. I want to make sure that we're referring to the right schedule. I believe that's right. 1 second. The Schedule 1 is the tariff. Schedule 2, you're correct, is the exemplar contract.
Okay, and really the point that I wanted to ask was, it is simply an exemplar contract. Meaning
Yes.
it's not, it hasn't been executed, correct?
It is not executed, Mr. Keeble. Certainly, it was informed with a lot of specific negotiation with Design Case Velvet to get to this exemplar status, because we both had to have a high degree of confidence that we could make this work. But I think my testimony says that yes, for sure, the intent would be to enter these market rate contracts closer to the time that a customer intends to take service under the tariff, so that we have the most relevant pricing to set in these contracts.
Okay, and that was my understanding too, Mr. Ives, but during her questioning of you just a few moments ago, Ms. Bell indicated or asked you a question about whether you had come to an agreement on something before you signed, I thought she said, the market contract. So my question is, have Evergy and Velvet signed a market contract?
We have not signed an executable market contract. We have agreed in principle to the structure that would fit the exemplar contract, utilizing best available pricing data at the time we were negotiating. But we have both agreed that that pricing will have to be reevaluated before we sign and execute a contract that can come forward to the commission under this tariff.
Okay, I thought I was with you for a second. So, I mean, without all the further explanation, you're saying that you, Evergy, have not signed a contract with Velvet for the market rate. Is that true?
We have not signed a market rate contract that's executable under the tariff until it is reevaluated for pricing.
Have you signed one that's not executable under the tariff?
We have signed one in the form of what our negotiations were to set a price that would be available were we to execute it currently, so that we could both acknowledge our agreement that we negotiated a contract that could work for us, which is substantially informing the exemplar contract that's in Schedule DRI 2 of my testimony.
Okay, so you say it is informing the exemplar, so it obviously had to come before the exemplar contract, correct?
Well, we had to come to an agreement on something that would work before we could file a request for the tariff with the commission, or we might have been wasting everybody's time.
Well, you still might be, but.
I hope not. I hope we are not.
Have any of those the contract you have executed with Velvet, has that been submitted with the application or provided in response to data requests, to your knowledge?
No, because it's not executable until it's updated for pricing at the time it's closer to service.
Well, but if it's a contract that, well, was it requested to your knowledge in data request?
To my knowledge, it was not requested.
Okay.
I apologize for interrupting. What contract were you referring to there, for the sake of the record?
This mystery contract between Evergy and Velvet that Mr. Ives said informed the creation of the exemplar contract. I think that's all the questions I have, Jess. Thanks.
Thank you, Mr. Keevil. That takes us to Mr. Kleiser.
Thank you, Your Honor. Good evening, Mr. Ives.
Good evening, Mr. Kleiser.
I'm not sure when you can start wishing somebody a good evening, but regardless. So I want to talk about the very first question I think you were asked by Ms. Bell, which really kind of threw me for a loop. And if I remember correctly, that question was whether or not Evergy would offer a contract if the OPC MECG staff non-unanimous stipulation agreement tariff was put into effect. Do you concur that that was the question, or substantially similar?
That was substantially similar to the question, yes.
All right. And your response to that was that Evergy just won't offer a contract if the OPC MECG staff stipulation tariff is put into effect.
That was the first half of my answer. The second half was that I'm not sure that a customer would accept it after going through the implications of the tariff as proposed.
All right. Well, look, we need to separate these because they're very different things. Whether or not a customer would take under it and whether or not you would offer it. I just want to confuse that. I'm going to confuse myself here. I just want to discuss whether or not you would offer the contract. So.
Yes, I would not offer the contract as proposed.
What you're telling me is if a customer comes before you and meets every one of the availability requirements under this tariff, you, as Evergy, can just unilaterally say, nope, we're not providing service to you.
Well, I think we've had a lot of availability discussion, and I think what it says is we'll evaluate the criteria, including the economics, to all parties. And ultimately, I think you went through some language with Mr. Lutz that said availability could be subject to review, but to get to a market contract rate as is currently contemplated under the tariff, it takes an executed market contract between Evergy and a customer, and unless the commission intervenes on the applicability language that says that they can review it.
Okay, there's a lot there, and I think we kind of need to unpack it just a little bit. So let's start with the simple one. Do you believe Evergy has the unilateral ability to deny availability under the terms of either stipulation? Let's start with Evergy's version.
Under Evergy's version, the tariff says the company will fully evaluate each customer's operation and the expected impacts to the company and remaining retail customers, and will determine a customer's ability to participate in this rate based on that evaluation. The company will notify the commission if participation is not allowed. Participation in the rate will not be allowed if the company or the commission determines it to be uneconomic for the company or the remaining retail customers. That language says to me that we can make a determination that it is uneconomic to the company under the provisions put forward in the tariff advanced by OPC, MECG, and staff, and we would notify the commission of that decision.
Great. We'll circle back to that for a second. So, but just to make sure it's clear, you're saying you can only not offer a contract if it's uneconomic.
Well, I just read it. So we'll fully evaluate each customer's operation and the expected impacts to the company and remaining retail customers, determine a customer's ability to participate in the rate based on that evaluation. So I think if we were uncomfortable with the customer's operation and how it would impact the availability of this tariff, or uncomfortable with the expected impacts to the company and remaining retail customers, we could make that notification to the commission under the tariff that we've put forward.
So again, under your tariff, you can unilaterally deny availability to a customer.
Under my tariff, I can notify the commission that the participation is not allowed and that the company or that participation will not be allowed if the company or the commission determines it to be uneconomic for the company or the remaining retail customers. So there obviously is a role for the commission in that once we notify them, if they wanted to question our full evaluation under that tariff provision.
I'm sorry, you say it's obvious. I'm not so sure that I consider it the same thing, because I'm still stuck on this idea that you're telling me we wouldn't offer a contract under this, which leads me to believe either that you've already determined it's uneconomic, even though the prices haven't been set, as we just had that conversation, or you just have the unilateral ability to not offer a contract. And at this point, I'm very confused as to which route you're going down.
I can't read the language any clearer than I've read it twice now.
Let's move on really quick then to what the OPC offered, because we had additional language that said the availability will be subject to commission review. You would agree with me that under that circumstance, even if you were to deny the availability, a customer could come before the commission and say, hey, I deserve to be on this contract. Let me.
I agree with that, Mr. Kleiser, and I would also say that under the company's view of the tariff, if I notify the commission of participation not being allowed, I think the commission still has the ability to respond to a customer inquiry like that and have the same discussion that your added sentence does.
I might circle back to that in a second. Let's move on really quick. So, if I understand what you're trying to say, your position is effectively that somehow what the OPC, MECG, and staff have put forward would make it effectively impossible for a contract to be economic to the company. Is that correct?
I think the combination of the factors that have been changed by the tariff put forth by the three parties has changed the fundamental of the relationship, and I think it will not work as intended with the work we've done to date with our design case customer. We would have to go back and consider if there was a way to make that tariff design work between the customer and us, but I wouldn't be able to execute what I plan to execute under the tariff as we constructed it.
With your test case customer. Okay, my point though is at a larger level. Are you suggesting that the changes that were made in the OPC MECG staff proposed tariff would effectively make it impossible for a contract to be executed that would be economic to Evergy?
I don't know about impossible. I think it's much more unlikely and carries much more risk. And there is not, you know, we've talked about, or some people talked about in their opening statements, significant profits and a number of things like that Evergy is pursuing. That the only thing that's not a pass-through in this tariff design currently is the investment that's made on behalf of serving the customer, in this case, some substation. So if there's more risk and more cost or exposure to the company, it doesn't take a whole lot to make this not an economic contract for Evergy.
Okay, first of all, I appreciate that you want to say a lot in response to this question. I'm trying to keep this a little bit short, so just bear that in mind. All right, walk me through exactly what changes make it so uneconomic for Evergy, and that's the key I want, for Evergy. What specific are the changes that you're referring to?
I think the hold harmless is a change that it is difficult to evaluate the risk on that, but I think not having the ability to make an all relevant factors discussion, which is really the only difference in the two, creates added risk to Evergy. I got to evaluate how much that means if the commission ultimately decides they don't need to look at all relevant factors.
Okay.
I think that the RESRAM as proposed by the parties in combination.
Hang on, just 1 second. Who are the parties in that statement, please?
I'm sorry, I thought we were talking about the tariff proposed by, thought we had been talking about the tariff proposed by OPC, MECG, and staff.
That's fine. I just want to make sure it's clear for the record. Continue. I apologize.
That's okay. So those three parties, their proposal on RESRAM, in my opinion, combined with the proposal on hold harmless, could create risk for Evergy that would need to be impacted before I would move forward with the contract as currently designed.
Let's start with the RESRAM one. How exactly does the OPC staff MECG proposal create risk to Evergy with regard to the RESRAM proposal only?
Well, the first part is I'm not sure how I implement it in a 5-year contract with a fixed price, but that's probably left for a later question. But assume I can't change the price with the customer contract for 5 years, and assume that there's a cost that needs to be paid that goes beyond the renewable energy contribution charge. There's a path I could see that parties would assert that could fall to the hold harmless if I can't adjust my arrangement with my customer.
Just to be clear, the contract that you're proposing has a price for capacity service, right? I mean, that one should be a simple yes or no.
Yeah, it covers capacity, sure. It's got nothing to do with the RESRAM, but
Let's keep this moving quickly. Does the price for capacity service, is that gonna about change over the 5-year period of the contract?
no,
Is the price for all other services gonna change over the 5 years of the contract?
yeah, I mean, for all other services, let me make sure you're pointing me to the right term. Number 3, number 3, go ahead.
I'm trying to figure out what parts of your tariff actually are variable, because my understanding was that only the rate for energy service was variable and only in the sense that it's based on the SPP.
In terms of the contract, in the 3-part rate, the rate for energy service is variable, for sure. The rate for capacity is set for the customer, but for a 5-year term based on contracts that are either entered or projected cost to serve.
So at a basic level, it is entirely possible for Evergy to set a rate for a 5-year term without exposing itself to too much risk, because it's already doing so in this contract.
I don't know about that in regards to RESRAM.
That's fine, I'll move on. Let's move on to the hold harmless provision. Would you agree that contracts that were entered or executed according to the SIL tariff were economic for Evergy?
State that again, you kind of broke up. Sorry, Mr. Clouser.
Would you agree with me that contracts that were entered into or executed according to the SIL or, forget it, special rate for incremental load service tariff that Evergy West has in effect were economic to Evergy?
The one I have has been at this point. The contract has not run its full term.
You would agree with me that it is possible for a contract to be executed that is economic, that has the same hold harmless provisions that are found in the SIL tariff?
Sure. I mean, it's certainly possible. That doesn't change that the risk has increased with the language that you proposed, and you were asking me why I wouldn't move forward with it.
I think I'm good for now. Thank you.
Thank you, Mr. Kleiser. We'll go to bench questions. Are there any commissioner questions for Mr. Ives? If you're on a phone, commissioners, that is *6 to unmute. And once again, for our listening audience, we do have all commissioners in attendance on WebEx. I'm not hearing any questions. The judge does have a handful of questions for Mr. Ives. Mr. Ives, I would like to start with a phrase that I have seen in all incarnations of the proposed tariff, and that is the phrase, including all applicable SPP charges. I am looking at the EMW Velvet Schedule 1, page 3. I don't know why I'm holding it up. I'm not on camera. I'm on page 3 under number 2, rate for capacity service. In the EMW Schedule 1, it's the red line language, but I noticed that it also appeared in the OPC staff MECG Schedule 1, and it even appears, I'm told, in the very original Schedule DRI-1. Would you please inform me what is included in, quote, all applicable SPP charges?
Yeah, I'll give it a shot. It's easier to talk about all applicable SPP charges when you move up to item 1 in the rates and conditions and the rate for energy service. We added the clause in item 2 for capacity service, Judge, based on feedback from parties throughout this proceeding. I believe my current assessment, my team's current assessment, is there are not SPP applicable charges in the capacity area, but it doesn't, I mean, that presumes there wouldn't be over the term of the contract, so we've agreed to add it. But if you move back up to the energy, there are a number of charges that come from SPP when you price energy at the day ahead price at a node to serve a customer like we're proposing, that address, I'll call it, additional cost and considerations that SPP bills for, whether that's providing for spinning reserves, or if you had a deviation between day ahead and real-time prices that it would cause a make-whole payment. There just are a number of, I'll call them billing charge codes that SPP submits charges through on a monthly basis. And this commitment is there to say any of those costs that are applicable to load that's being served under this contract will be picked up in the energy price that's billed out to this customer.
And all of those costs would be in the contract that would be brought to the commission for review ahead of time.
Yeah, certainly when we bring that contract in, we'll have further definition of our expectation about those charge codes, specifically to kind of the underlying fundamentals of the contract that's brought forward. Now, they will change much like the energy cost on a period-to-period basis, right? Because those charges vary that come from SPP based on activities that are going on across the entire footprint. So we'll need to understand the codes that need to be addressed, and then we'll need to pull those costs in from our SPP billings to convert those into a bill to a Schedule MKT customer.
Thank you. Under the rate for capacity service, how do you envision that Evergy will provide the work papers supporting its good utility practice?
Yeah, so a couple things, right? I mean, we procure capacity as part of our business, right? I mean, that's what we do, either through the construction of capacity to serve customers or the execution of bilateral contracts to take capacity from customers. So we would need to be able to demonstrate not only for parties, but demonstrate for the customer that we're putting that capacity in place for, that we've used good utility practice in evaluating those. So we'll have to do some analysis around the cost of construction compared to RFP cost for financial capacity, so that we can demonstrate that we've taken the right steps consistent with our charge.
And when would Evergy be supplying that supportive paperwork to the commission?
Yeah, so the intention would be when we are talking about starting that 90-day clock, we actually have talked with the parties, and some of the language that's added in here talks about the documentation, providing the documentation and the support underneath the details that are in the contract. And our goal would be to have that package ready to come in as work papers at the time we make that contract tariff filing, or I'm sorry, market contract filing, so the parties have access to that out of the gate versus having to submit a request for discovery for that type of information and have a time delay.
And I may have missed it, but would you define good utility practice, if that is definable?
Yeah, it's a relatively general contractual term used in order to say you have to be doing your diligence. You need to have an evaluation and an assessment and have done appropriate research and have appropriate support for what you're advancing. That's kind of a layman accountant's way of describing good utility practice. It's a very common term in the industry.
Okay, and still in that same paragraph, it states the rate and all elements included in the rate will be specified in the special high load factor market rate contract. Does Evergy plan to file the work papers supporting each of those elements included in the rate when it files the contract?
Yes. I think in the last sentence, like in number 1, all elements included in the rate be specified, that the intention of that in combination with some of the other language in the tariff, particularly under the contract documentation, talks about details, in our tariff in particular, that first paragraph, details about the rate, start date, term, operating parameters, terms and conditions related to the rate, and all assumptions, inputs, and calculations used to determine that rate, filed with the commission and documented through the market rate contract.
Thank you. I'm going to switch gears. Would you describe the Omaha Public Power District? Just what is it for the record?
In general, it's kind of a state cooperative type approach, if you think about it that way, to serve customers up in the Omaha area. I mean, there's more of those structures up there that are large service providers to customers. There's OPPD, there's a NPPD. They're not a vertically integrated IOU, a shareholder-owned IOU, but they're more state, local sponsored. But they're doing the same, in essence, they're doing the same work that we're doing in terms of, providing and supplying electricity and the wires to get that electricity to customers in their territory.
Thank you. In your direct testimony, you had discussed why predictable pricing was necessary. Could you expand on that?
Yeah, for sure. I mean, I've been here a couple times and it's in testimony. I mean, we've been discussing the opportunities for customers like Velvet, with 3 that I can think of off the top of my head, potential customers over the last 3 or 4 years, probably longer. One of the most significant hangups for these large high load factor customers like these data centers is a predictability of price when they're getting ready to come in and Velvet's case, invest $800 million to put a location in. It is by far, electricity is by far probably the most significant input to their cost of doing business once they've opened up their operations. And they're looking for areas across the country where they have strong predictability of price, 1, 2, very competitive price because it's such an input for them.
Thank you. I'd like to turn now to nodes, and I'm going to ask for some some expert type information. Would you please describe what the EMW node is? You referenced it in your direct testimony at page 7, but I want to, for the record, describe what the EMW node is, what's measured at the node. Does Evergy have just one node, and does Evergy Metro have a separate node? Sorry to throw all of that at you at once, but I want to kind of give you a flavor of where I was going with that.
Yeah, no, that's all okay. And I probably should have let you talk to Mr. Lutz about that, because he's much more versed in that than I am. But from my standpoint, Evergy West has one load node that we're served at by SPP for bringing energy in to serve our customers at Missouri West. And we have, pretty sure we have one load node for Metro that we bring in the energy from SPP to serve that load. So that's kind of the SPP construct, and then you also have points of interconnect with your sources of generation for our outflow of energy that goes into SPP. We get paid for our outflow of energy based on pricing that occurs at the node near our generating source. We pay for energy at the EMW load node, the one that we have that serves our load. So that's kind of the construct of the flow of billing between a utility operating in SPP and SPP, both from the revenues we receive from the supply we provide, and then the cost we receive from the load that we take at that load node. I'm going to pause because I may not have answered your entire question.
No, you're good. Are all of those things measured at the node? And I'm a little confused here. Are we talking about electricity flow? Are we talking about the price or the transportation? What's measured there?
Yep. Yeah, it's a great question. It's really everything. When you're bringing electricity to a load node, all applicable SPP charges are put on the bill based on the electricity you receive at that load node. So those all applicable SPP charges all come in on the bill based on what you take for kilowatt hours at that load node.
Okay, I have just a handful of questions left. We have heard discussions today about the new core tariff and how that may or may not be suited for the Velvet Tech project. Just for clarity for the record, could you please identify which tariff Nucor is currently served under?
It's under, I don't know the specific number, but it's at schedule, it's probably a schedule SIL. And we can get that to you, Judge, if we need to get you the specific tariff number and reference. I just don't have it in front of me.
No, I think SIL was the identification I was looking for.
Okay.
And that really kind of leads to this question. I want to kind of compare. We've heard so much comparison of the new core tariff. Would you please describe to me what are the shortcomings or failings of that tariff if it would be applied to this current situation in Velvet Tech?
Yeah, so the simplest answer I can give you is that tariff is designed for Evergy to source and provide the renewable generation to support a customer on SIL. our arrangement and our discussions with parties that are interested in Schedule MKT have indicated that that's not the best course of action. They have some very specific corporate renewable standards that they intend to meet. They generally are a sophisticated group of customers that already understand how to interact and engage and own, I'll call them utility scale, but large scale renewables across the country and globally. And it has become more difficult for Evergy to source that renewable generation to meet those requirements at the size and the potential scale of customers that would come in under Schedule MKT, while we're also working on our plans to transition our current generation portfolio to greener generation in support of all of our non-MKT customers. And I mentioned in testimony, there are also some implications from a credit rating agency standpoint that put more pressure on the utilities ratings, even with a purchase power agreement to do that type of work, that also would hinder our ability to do what we need to do for other non-MKT customers. So with that, we had to seek out a solution that would allow the customer to meet their corporate renewable requirements, allow them to participate in SPP with those renewables and take energy from us, which was important to them as well to us. And that's how we came to the structure we have. The only other thing I would note, and I'm sure there are more nuances, but the one we have talked a lot about obviously is the hold harmless protections that are in the SIL based upon the facts and circumstances that were negotiated by all parties at the time for that tariff are no longer workable as we move forward and consider additional customer adds the size of those that we're talking about with the Schedule MKT.
Okay, and with that, Mr. Ives, I'm going to turn to our final questions. These are the same questions I've been telling the councils about and also asked Mr. Lutz, and we'll be asking the other witnesses that come through tomorrow. I'm tempted to give you to recite the list back to you that Mr. Lutz identified and that you also identified when you were speaking with Mr. Kleiser. Let's do that. My question is, Mr. Ives, if you could please discuss the sections of the OPC staff MECG proposed Schedule 1 from last night. I'm going to list these sections, Mr. Ives, to see if we can get through this a little faster. Looking on the OPC staff under availability, the first bullet point, the company recognizes and accepts the new addition of the fragment of a sentence at the end, starting, provided the new customer's current load reaches a monthly demand minimum of 50,000 kilowatts. Is that correct?
Yes, sir.
Okay. Evergy would object to the bullet point that references section 393.1640.
Yes, sir.
Evergy would like to see the substation voltage offering that is in the Schedule 1 proposal from EMW and Velvet last night. As I'm turning the page, I'm sorry, thank you, Mr. Ives. As I'm turning the page, we get to I'm sorry, 2 pages. We need to get to page 3 of the OPC staff. The company is recommending changing under the term, changing the second reference to 60 days to be 90 days.
Yes, sir.
The company is objecting to, and I'm flipping the page now, additional provisions, number 3.
Can I take you back just one step, Judge?
Please.
I just want to be super clear, but in that top part of the contract documentation, that there are some minor wording changes between the 2 tariffs in that specifically in the first 6 lines of contract documentation. I don't believe I have any concerns with them, but I just wanted to point out for you that they were there.
Give me just a second as I find, okay, under number 4, contract documentation.
Yeah, I don't think the changes that are in the OPC MECG staff version give me any pause. I just wanted to make sure you were aware there are a few changes there.
All right, I've noted that. And then Evergy is opposing the hold harmless, the second sentence of paragraph number 3 under additional provisions, and also section 4, and I'm trying to parse how many sentences.
Yeah, I think if you start in the middle of OPC stipulation on the 5th line down in the middle, the sentence that starts, if the customer's rate revenues.
Okay, I got you.
I think from there to the end.
However, while Evergy is objecting, Evergy is also proposing their own hold harmless provision that includes the ability to, and I can't find the language, present evidence for the Commission's consideration of other economic benefits. So the Evergy is opposed to this hold harmless language from OPC and staff and MECG, but does have its own that's proposing. Is that correct?
That's correct. I mean, you read the one sentence that certainly we've spent the most time talking about today in the hold harmless discussion. I would note that in the bottom half of our hold harmless, our version differentiates that if the Commission determines there's a deficiency that needs to be addressed, half of it would be covered by the customer that's under the market rate contract, with half to be borne. That level of specificity is not in the OPC and other parties stipulation.
Thank you. I also have Evergy objecting to, again, under additional provisions, I believe it is the second paragraph of paragraph 4. And again, this is the OPC staff MECG Schedule 1.
Yeah, I think that's a continuation of the hold harmless, and
okay.
we think all of that discussion should be replaced with the hold harmless provision that we advanced.
Thank you. And the OPC staff MECG Schedule 1 does exclude FAC charges, which Evergy agrees with, but in paragraph 7, the OPC staff MECG Schedule 1 does not waive the res-ram potential charges. And Evergy objects to that and does supply their own language. Is that correct?
That's correct. Our recommendation would be to replace that item 7 in the OPC and party stipulation entirely with the redlined item 6 in our version.
Okay. Excuse me. I was trying to get through all of those questions that I had asked Mr. Lutz in a more economical version. Now that we have covered all that, Mr. Ives.
I'm sorry,
Yeah,
Judge. I have one more item, and it's in the OPC paragraph 5 under the additional provisions.
I'm there.
In the last line, the last sentence in that section, they have added the discussion of securitization of company assets. And I might have addressed that earlier in response to a question, but I think it's inappropriate and premature to put that into this tariff. And I think the correct place for the commission to ultimately set applicability of securitization charges will be in their financing order authorizing securitization.
Thank you, Mr. Ives. Let's wrap up our discussion of the two competing tariffs. Do you have any other things that you would want taken out or put into the OPC staff MECG Schedule 1, other than what we just listed?
No, I think that summarizes it well. I mean, I would just reiterate, Judge, I mean, you know, by and large, there's been a lot of work done by the parties, and there's a lot of similarity in the language, which both versions are a fair amount different than the original tariff filed in my testimony. So we're accepting of the remainder.
Thank you, Mr. Ives. Let's turn to the Evergy Velvet proposed Schedule 1. I just would like to offer you an open-ended question. Would you like to go through that exemplar tariff and briefly explain any of those key provisions, why they were included or why they were not?
You know, I think we've covered it, Judge. I mean, I think the items that we discussed as differences when we walked through the OPC and parties stipulation, it's kind of the inverse here, right? So I feel like we've addressed everything, and I think we've talked either with you or in my testimony with others today on, you know, at least Evergy's perspective on the versions we have advanced. I would just say maybe one thing, sorry for rambling, but on the res-ram discussion, which is paragraph 6 at the end of additional provisions in ours, you know, I think we believe, and we provided a stipulation to go along with the tariff, that the commission has the authority to provide a variance from the rule that would achieve the purpose we've laid out. I know, and I won't elaborate on this because I know all parties will brief the legal positions on all that, but I would just say beyond what's in the stipulation, we would ask the commission to accept or in the tariff, we would ask the commission to order the variance that we also put in our stipulation.
Okay, I have two final questions. First, I want to follow up on Mr. Kleiser's inquiry regarding risk. I'm trying to wrap my head around the risk that the company would take, and in this situation, if Velvet or some other high high-load customer starts down this path and Evergy builds the necessary infrastructure, and then in 3 or 4 years, I'm not worried about how many years, but Velvet takes a turn for the worst. Computers are outlawed. I don't know what happened. But is the risk that Evergy is concerned about, if that would happen, then who is paying for the leftover costs of service, specifically that infrastructure? Am I right in understanding that Evergy's concern is that if something should happen to Velvet before that cost of service payback is met, then Evergy shareholders would have to shoulder that burden? Is that the risk that you're concerned about?
Well, I think that's a component of the risk for sure. Now, I'll temper that by saying that I think it's highly unlikely that the customers we're talking to under this tariff are going to face that circumstance. But that said, for sure, I believe if that happened and the language advanced by OPC and parties on hold harmless were in place, then that's what would happen. I mean, there would be a mathematical adjustment that would occur and never get brought before the commission that would ultimately impact Evergy for making an effort to participate in economic development in Missouri and providing an avenue for the state to have those opportunities. I would suggest that there should at least be a discussion about that. We should evaluate whether that investment, that capacity can provide benefit to other customers on the system. We should evaluate whether it was in the best interest of the state to make a run at a customer like Velvet and have an opportunity for them to come to Missouri. And if it didn't work out, I would at least want to explore the question of whether that should all be shouldered by Evergy if it didn't work out. That seems unreasonable to me to be in that situation on a mathematical calculation.
Thank you, and that brings me to my last question. This is going to be a little bit more of a thoughtful question, a little bit out of the box. We were briefly talking about purchase power agreements. Would you call or would you consider the proposed MKT tariff a type of a virtual PPA? That might sometimes also be called a financial PPA rather than a physical, is kind of what I'm getting at.
Yeah, I'm going to parse it into two pieces. I wouldn't characterize it that way for the energy charge, because I would think of a virtual PPA kind of having a set price for energy, just like a physical PPA would, whereas the energy charge that MKT customers are paying is a true market cost of energy and is going to vary based on market dynamics. And what the MKT customer is proposing to do is, from their side, manage that risk by having resources supplying energy into the SPP, and also use those resources that are supplying energy to manage their risk to provide the renewable attributes that help them meet their corporate renewable targets. And in our proposal, help Missouri meet its RES compliance mandates. I'm sorry, one more thing. I would offer that the provision of capacity can look a lot like the form of a PPA, because if we use good utility practice and the best source to supply them on the capacity is a financial or a bilateral transaction to secure that capacity as opposed to building directly for them, that'll look a lot like the characteristics of a PPA for the supply of capacity.
Thank you, Mr. Ives. That's all the questions I have. That does bring us back to recross. We'll follow the same format. We'll start with Velvet Technologies. Ms. Bell.
Thank you, Your Honor. No recross.
Thank you, Ms. Bell. That'll move us to Google and Counselor Mills.
Yes, thank you, Judge. Mr. Ives, the judge asked you some questions about areas in the staff OPC, MECG tariff that Evergy disagrees with. Just to sort of take that to the logical conclusion, if the commission's order in this case were to authorize Evergy to file a tariff that looked just exactly like the tariff that those parties have proposed, would Evergy file such a tariff?
Well, I'll take one pause, and I'll give you what I believe. We certainly would have to look at the language of the order and the support of the commission's order in that regard to understand the background behind it. But if you get to the finish line and that's the final answer, right, sitting here today, I don't believe we would file that tariff with those revisions.
Judge, that's all I have. Thank you.
Thank you. That takes us to Mr. Woodsmall.
Yes, building off of that last question, if the commission ordered you to file such a tariff, would you do it?
Well, I tend to not like to not follow commission orders, so I guess we would have a discussion internally that might result, Mr. Woodsmall, in some requests for reconsideration and things like that. But if ultimately they ordered it, our role is to comply with commission orders.
Okay, and so you do agree that the commission has the final word on this, not Evergy?
I object. I believe that calls for a legal conclusion. I think that the commission, in its order in this case, will either authorize Evergy to continue with the tariffs that were filed with the case, or authorize them to file a different tariff. I don't believe that there's an outcome in which the commission can order Evergy to file a tariff that it disagrees with. So I think that's part of the premise of the question. And I don't think this witness is as a non-lawyer, has the experience and the expertise to answer that question.
Evergy would join in that objection, Judge.
Your Honor, as we've had many objections already today on the basis of people being asked legal questions, and they all came back to, you've got a lot of experience. Well, Mr. Ives has been their chief of regulatory for 11 years. I think given all his experience, he could tell us whether he believes that the commission has the ability to order them to file a tariff.
I'm going to overrule the objection and allow the answer. Mr. Ives is perhaps giving his view of what might be a legal question. But again, I'm going to trust in the commissioners to be able to parse that themselves. Mr. Ives, go ahead.
Yeah, I mean, Judge, I would just say our obligation is generally to comply with commission orders. All that said, I don't make the decision on my own. I have regulatory legal counsel that sanity checks my efforts to play lawyer from time to time. So it'd be a joint decision here, but we would generally endeavor to follow commission orders.
I'll let it go. Thank you, Your Honor.
Thank you, Mr. Woodsmall. Let's move to Mr. Keevil.
Yeah, in the interest of, time and, everything else, Judge, I don't have any further questions.
Okay, that'll take us to Mr. Kleiser.
Thank you, Your Honor. I'm going to try to keep this brief. Good evening again, Mr. Ives.
We are a lot closer to evening now than we were before, Mr. Kleiser.
Yes. All right, so with regard to the question on risk that was posed to you by the judge, and, you know, the question of whether or not, Velvet Tech goes out of business. Do you recall that question? Let me start there.
I do recall that.
All right, I want to just drill down and make this really, really clear. Under your understanding of the OPC staff MECG tariff, if Nucor went out of business, you believe the company would be on the hook for picking up any costs that were unrecovered from Velvet Tech. Is that accurate?
I think so, yes. I mean, I think the way it's structured, that there's a consideration of the costs that are incurred on behalf of that customer compared to the revenues that come from that customer. If they go out of business, there aren't any revenues, and I think we would at least be subject to positions of parties that maybe there are still costs related to that investment that need to be addressed.
And the key difference, in your opinion, with what OPC staff and MECG put forward and what Velvet Tech and Evergy put forward is that in the situation of the latter, you can argue for why ratepayers should pay a portion of those unrecovered costs, correct?
We can argue for the commission to consider all relevant factors, yes, in our position.
One of the practical implications of that would be that you would want to argue that other customers should bear unrecovered costs, correct?
I would want to demonstrate why they might be beneficial for other customers, or there might be other considerations to bring to bear, yes. And the commission would ultimately make the determination.
Yeah, but I want to make sure that it's very clear on the record what the actual practical impact of that would be. That would result in other customers paying for the costs incurred to serve Velvet Tech. Can I get a yes or no?
You can't get a yes or no because I disagree with the premise of the question. It is not.
What would be the purpose of arguing for all relevant factors if not for arguing why other customers should pick up part of the tab?
Because in that situation, there might be other customers that aren't on the MKT tariff that can benefit from the utilization of those resources that are no longer supporting Velvet. And unless I get to make that argument and put that position forward, nobody will ever know that. I'll just have made a mathematical adjustment and it'll be gone.
To be clear, the whole purpose is to make sure that non-MKT customers can be forced to bear part of the cost of serving the MKT customers.
No, I disagree with that. That's not what I said.
Is there any circumstances, in your opinion, where it would be acceptable for a non-MKT customer to bear any part of the cost of serving an MKT customer?
Yeah, I do think it's possible that that could happen. We had this discussion in the hearing earlier today where there are revenues that come in, let's call it for a significant supplier to somebody like Velvet, that are accruing to the benefit of all non-MKT customers because they've come into the service territory and they are reducing the overall cost to non-MKT customers. In OPC staff, I'm trying to answer your question.
Can we keep things yes or no, please, or at least shorten them?
I'm trying to give you a scenario because you asked if there was a scenario. I'm trying to explain one.
And the answer is yes, there's a scenario. I got my answer.
Fair enough.
So the purpose of your language in your tariff regarding your hold harmless is to make sure that you can make that argument and ensure that those non-MKT customers are paying part of the cost to serve MKT customers. Correct.
No, the purpose is to give the commission the opportunity to make the evaluation of whether that's appropriate or not.
You know what, fine, I'll take that. All right, I'm gonna move on to securitization, that's my last topic. I'm gonna make this, again, I should just stop trying to say anything about making it brief.
Yeah, we're past that point.
I know. All right, I wanna make sure I understand how this works. Let's say hypothetically that the commission does not adopt the OPC MECG staff language regarding securitization. That doesn't make it into the tariff, all right? That's our hypothetical. You with me so far?
I'm with you.
Okay, the tariff is enacted, a customer takes service under this tariff, and they have a contract in place. You with me so far?
I am with you so far.
After that, the company decides to securitize an asset. And let's assume, for this purpose of this hypothetical, that the law requires the cost of that securitization to be borne by all customers. How does Evergy recover the cost of that securitization from the MKT customer, given that the tariff is already in effect?
I would refer you to section 3. I would refer you to section 3.8 of the exemplar market contract that's on page 3 of 7 of DRI 2 to my direct testimony. There's a section called mandated cost recovery mechanisms, and it addresses what I think your question is.
And
It's
what's
in
the
my
problem
testimony.
out of the exemplar contract and putting it directly in the tariff?
What's that?
Why couldn't we move that out of the contract, the exemplar contract, and put it directly in the tariff?
I don't think it's necessary. I think the commission will make a determination of what tariffs a securitization charge apply to when they put out a financing order. Not a single tariff in my tariff book today has that language that you're trying to put in this one. And I suspect it never will, because the commission will make that determination when they put out a financing order authorizing securitization.
All right, no further questions.
Thank you, Mr. Kleiser. That will take us to redirect from Evergy. Mr. Fisher, go ahead.
Yeah, thank you, Judge. Just briefly, let's go to that last set of questions from Mr. Kleiser first. When you were talking about, I think, the difference between the OPC hold harmless language and the Evergy Velvet language, is it correct that under the Evergy proposal, the company would come forward if someone proposed a disallowance and suggest there might be other all relevant factors that might mean that even though the revenues did not cover the cost, there might be other factors to be considered, whether it be a disallowance at all?
Yes, and it could be because the determination of the math that OPC and parties propose is at a single point in time in a filing and not considering the full range of benefits over the 5-year contract with the customer. Or it could be that there are other revenues that are benefiting all non-market participant customers that should at least be considered by the commission before we made a mathematical adjustment as proposed in their tariff.
Changing topics, I believe Judge Hatcher asked you about the phrase including all applicable SPP charges. Do you recall that discussion several minutes back?
I do.
I'd like to refer you to the Evergy Velvet stipulation on page 2. Do you have that? In the
Evergy Velvet. Yeah.
Stipulation. In the middle of the
step, sorry.
Yeah, in the middle of the page there, it talks about applicable SPP charge categories may include, and then it lists administration, auction revenue rights, transmission congestion rights, day-ahead ancillary, day-ahead energy, day-ahead uplift, real-time ancillary, real-time energy, and real-time uplift. Are those the kinds of categories that you were talking about?
Yes, thanks for pointing that out, Mr. Fisher. I mean, those are categories outlined in the STIP, and as I mentioned, there are a number of discrete charge codes that SPP utilizes. My team that's responsible here at Evergy for evaluating those bills and those charges tell me that these are the major categories that set over each of those individual charge code types.
Going back to your cross-examination with Counsel for Velvet, I believe you indicated that you've been thinking about ways to resolve the conflict between the two stipulations on what I call the EDR issue. Is that, do you
Yes.
recall that?
I did. I had some discussion with Ms. Bell, and I think I had a discussion briefly with Mr. Mills about that too.
Have you made an attempt to memorialize that solution in writing?
Yes, we have a view on that.
Judge, I would like to have an exhibit marked. I'm sending it to all the parties now, and I'd like to have my counsel in Kansas City posted on the screen if they could.
Your Honor, and are we going to get a chance to then cross-examine Mr. Ives on the contents of this? It seems deliberately to avoid the process by dropping it in now. I don't mind if we can look at it tonight and then cross-examine him on it.
Well, not only that, Judge, but the farce that the cross-examination, which led to this redirect, was done by Velvet is just astronomical. I mean, the friendly cross whenever Ms. Bell is asking Mr. Ives or Mr. Lutz anything. So, I mean, we let it go, but to think that he can ask a question about something and then Mr. Fisher comes along and drops in a written statement from Mr. Ives, which sounds like they're trying to negotiate a settlement through the hearing process to me. I mean, this entire attempt is just ridiculous.
Your Honor.
Should not be allowed.
Go ahead, Ms. Bell.
Your Honor, if I may respond, until we received the stipulation from OPC last night, this issue wasn't in the list of issues, the testimony, or anything else. In addition, I believe my questioning was the very first questions to be asked of Mr. Ives, and he explained in this proposal in his testimony, if parties had additional questions regarding the resolution, my question was, do you have a proposed resolution? He stated what that proposed resolution was. If parties had cross on that proposed resolution, they had the opportunity to do it.
But now we have specific language, and like I say, the easy resolution is once we have this language, allow very, very, very limited cross to come back around on this language.
Now, the easy resolution is not to allow this language. Then Mr. Woodsmall would be the second easiest resolution. But this should not be allowed. This should be stricken, and we should move on and not condone such.
Judge, Evergy has the right on redirect to address the questions that were asked and to find a middle ground resolution that will help the commission find the public interest here. And we believe this language would be a long way toward getting to middle ground. I would ask that this be marked as Exhibit 7, and I would like to ask Mr. Ives a couple questions.
I don't mean to dogpile, I'm just throwing this out there. If they have a resolution and think they can solve it, just let them bring it up in their brief. What question does he have to pose about this? I mean, it should be explainable on its face.
I think I would like to make the foundation to ask that this be admitted into the record.
Again, objection, because the whole thing is just improper, because the the alleged cross-examination, which led to this, was from their buddy and tariff writing stipulation granting. It'd be like if I was asking Mr. Kleiser for something. I mean, they can't manufacture, and that's what they're trying to do here. Ms. Bell asks a question, Mr. Ives comes back with some general answer, and then Mr. Fisher comes in with a specific written document. That is not proper. It's not, I don't even wonder what basis this would even begin to pass by.
Judge, I could ask Mr. Ives to read this into the record, and he could do that on redirect. We're trying to just make it easy for the commission to understand what the words say.
I am troubled by lots of things here. I am troubled by, on redirect, having a brand new exhibit. However, hearing counsel argue against that raises questions in my mind about when exactly did the EDR issue become an issue? Because some parties have argued that OPC or the other parties brought this up relatively recently. I also have a duty to the commissioners, and having the verbiage set out is very tempting.
Your Honor, if I could answer your one question.
Yes.
It became known as an issue during a technical conference. If you look at the list of issues, it's not included there, but none of these are listed there. It just says what conditions, very general. So this has been known since a technical conference.
I'm sorry.
Go ahead. You're fine.
If it's just a matter of saying this is language that we think could solve it, again, they can put in their brief. I honestly don't mind if they just say, like, this is language right now. I have no problem with that. My concern is if Mr. Ives goes on to therefore talk about it and try and explain it and make a pitch for why it's a good idea that we haven't been able to respond to. That's the critical factor here. So if it's just a matter of saying, this is language we propose, again, I honestly think they can just do it in the brief and this isn't a big deal, but I personally don't have a problem with it just coming in now and just being, this is language, that's it.
Well, I think the judge was going in the middle of making a ruling, so I would like to hear the judge's ruling before.
I am also aware that it is 5 o'clock and that there does exist a world outside of the governor office building. I would like to stop here for tonight. Let this language get distributed. I saw that it was just emailed to everyone. That'll give everyone a chance tomorrow. Well, Mr. Fisher, then I have a question. You're going to drop this, let's say tomorrow morning, introduce this as an exhibit. Mr. Ives is going to testify and read direct. How exactly are the other counsel going to get to ask him any questions on this language?
Judge, I think that's at your discretion. We believe this is a middle ground way to solve one of our major issues here. This is the language that Mr. Ives has drafted, and I think he could testify that this would be the kind of solution he would suggest. If you want to let the other counsel ask him questions, that's fine with me. I think we could resolve it if that's all it takes. We believe this is in the public interest and it ought to be adopted.
So I'm hearing no one objecting to recessing tonight.
No, I'm certainly in favor of recessing.
and coming back tomorrow with this exhibit, with redirect, and then we're going to do what, recross
Very limited recross, yeah.
on just the EDR issue?
I'd say that's at
Okay.
your discretion, Judge.
And Your
And I'm
Honor,
gonna exercise, yes, go ahead. Ms.
Your
Bell?
Honor, I would ask that it not be on EDR, the EDR issue generally, but on this particular language. So very limited.
I am not sensing any heartburn in the room. I will use my discretion to do exactly that. We are going to adjourn. I'm going to stop right here for just a second. Mr. Kleiser.
Is there any other redirect after this that we could, or we just?
We're done, John, let's go.
The plan is for council. This is unusual. I agree. However, of moving the case forward and making all parties' presentations as clear as possible is important. So with that, my plan is adjourn tonight. We'll come back tomorrow at this point. Mr. Ives, are you going to be available tomorrow at 8:30 a.m. if you can just give me a nod?
Yes, Judge.
And we will then start with this exhibit on redirect. We will then depart from normal procedure, go through recross on this language, and then go back to our regularly scheduled program, which will include Mr. Brubaker as a witness, Mr. Fortson, Engineer Eubanks, Mr. Bush, Dr. Mark, and Lena Mantle.
And the other two.
Oh, and I'm sorry, you're right, and Ms. Hadaway and Ms. McCarthy.
And we'll take those up first before moving off of Evergy's evidence.
If the witnesses
Judge.
are available, yes.
Yeah, Judges Roger Steiner, Evergy. One is available at 10 and one's available afternoon. So I have a little bit of a time constraints, but we'll work them in.
That's okay. We will, we'll go with it and we'll cross that bridge when we get there.
Which is available first?
Which witness is available first?
Let me check my notes here. I believe it's McCarthy.
Okay. So the regulatory draw law judge is going to use his discretion. I have laid out the plan that we're going to accomplish tomorrow. I will restate it briefly and then we will adjourn for the evening. Tomorrow morning at 8:30 a.m., we will rejoin this hearing, again, both by WebEx and in person. We will begin with the redirect by Mr. Fisher of Mr. Ives, and then with the expected introduction of the exhibit, we will make an exception and allow recross examination on that language, and then we will move forward back to our regular witnesses and schedule. Are there any other issues coming before the bench tonight before we adjourn for the evening? Hearing none, we are adjourned. We are off the record.
Thank you,
Thank
Judge.
you all. Thank you, Mr. Chairman. Thank you, Commissioners.
Thank you, Judge. Will we use the same call in tomorrow?